admission, item number 1.
May it please, my lords. My lord, I have filed an affidavit this morning. My lords, I have served copies to the respondents also. In that affidavit, my lord, basically what I have said it is that, my lord, since the inspection by the High Court, my lord, only except for the construction of 21 culverts in the rock water awarded under the PMGSY scheme, that is from D01 to Kangtang village, my lord, 38 kilometers. In that stretch, 21 culverts have been constructed. Besides that, nothing has been done by the contractor till that, my lord. And my lord,
1 minute. Yes, please. Chief engineer is present. Yes, what steps have you taken against the executive engineer?
No action has been taken as of now.
What? Are you just going to file your affidavit? Direct the court to close the PIL and keep quiet?
No, sir. No, sir. Sir, I tender my unconditional apology for my inability to attend during the last
That's fine,
on the
that's
last
fine. We
occasion,
have
sir.
understood your problem. But then after the affidavit that you have filed, we have called for your personal appearance.
Yes, sir.
Because there's one particular paragraph where you have stated to close the PIL.
Sir, on this issue, as far as paragraph 4 of my earlier affidavit is concerned, I tender my unconditional apology. If there is any statement that demeans or is against the honorable court, as I have the highest respect for the court, whatever statement I have made was a prayer to the court for giving a direction to the respondent number 7, which is the contractor.
See,
And
one thing is this. Continuing with the PIL, closing the PIL is the court's prerogative. It's none of your business.
yes, sir, yes, sir. Sir, I'm sorry about that.
Now, we want to know what action you have taken against the executive engineer after he has submitted the false completion certificate. Are you just going to keep quiet?
No, sir, that matter will be taken up with the government, sir,
When?
at the earliest, sir.
At the earliest?
Yes, sir.
Could be 1 month, 2 months, 1 day, 2 days.
So action we will be
We
right.
want to know what you have done against the executive engineer for filing the false completion certificate. After that, we'll proceed with this case. Whether we release this case day after. Okay. We are listing this matter day after tomorrow. We'll see what steps you have taken against the executive engineer.
Sir, I pray for a month's time, sir.
No. When did you file the completion certificate?
Sir, all these things have happened during my predecessor's time.
We know
Sir.
that he's no more.
Yes, sir.
Unfortunately, he's no more.
Yes, sir.
But then at least the executive engineer is around. Show us what steps you are taking against him. We are listing the matter day after tomorrow.
Sir, if you can kindly grant us 1 month's time.
No. It's been quite some time. You've done nothing. He submitted the completion certificate in the year December 2013.
Yes, sir.
Now it's 10 years.
Sir, if you can kindly grant us a month's time.
We are listing the matter on Friday. Then. We'll see what steps you are taking against the executive engineer. After that, we'll proceed with the matter.
So, Mr. Additional AG, who has filed this affidavit?
My lord,
Who has filed this affidavit?
by the chief engineer.
Yes. The chief engineer has given you instructions to file affidavit, and who has filed this actual affidavit? Who has filed this?
By the department concerned, my lord.
You are actually like copy pasting the instructions given by the department. You are copy pasting the instructions. In fact, it is actually regarding executive engineer, the chief engineer has to actually give explanation. But insofar as the affidavit is concerned, you are responsible.
My lord, my lord.
You are responsible. You are not supposed to copy paste whatever instruction is given by the government.
My lord.
As Additional Advocate General, you are supposed to know what are the contents to be made in the affidavit, what are the contents which is not supposed to be made in the
My
affidavit.
lord.
And you are holding such a responsible post, and you are making such statements. In fact, the chief engineer, the officer is a layman.
Yes, my lord.
He will not be able to know what affidavit has to be filed. He will give his part of the story,
Yes, my lord.
but you are supposed to filter that. And you are supposed to actually make statements which are actually like proper for the court. Not a direction to the court to dispose of the PIL.
Yes, my lord.
It is your fault, in fact. I hold you responsible.
Yes, my lord.
I think next time this should not happen.
Yes, my lord. I pray.
For your sins, the chief engineer is made responsible. Today, this personal appearance.
Yes, my lord.
As I've said, regarding executive engineer, that is a different issue. But regarding the filing of the affidavit, which has given rise to this personal appearance,
Yes, my lord.
you are responsible. In future, I think you should not casually take up these issues like this.
Yes, my lord.
Whatever the government is giving you for filing parawise, you filter it out.
Yes, my lord.
What should be used? What language should be used? What para should be used before the court? What should not be used? You filter out.
My lord.
I think you are squarely responsible for this. And because of your fault, the chief engineer has to give his personal appearance. Please avoid this practice
My lord.
in future.
My lord.
Yes, Lordship.
Heard Chandi Yangan, learned counsel for the petition. Stop. Your good name, please?
Kevin Nakro.
Mr. Kevite Nakro, learned, Mr. Chief Engineer, is present in court today. Stop. On a pointed query made by this court as to what steps has been taken against the respond number 11, public executive engineer, with regard to the issuance of false completion certificates in the month of December 2013, he submits that no steps has been taken. Stop. We intend to proceed with this PI only after appropriate steps has been taken against the executive engineer oblique respond number 11. Accordingly, list this matter again on 3rd of February 2023 to enable the chief engineer. No. To enable the chief engineer to, don't say, on 3rd of February 2023, to enable the chief engineer to show what steps has been taken against the executive engineer. Stop. The personal appearance, the chief engineer shall be present in court again on the next returnable date. That much only we are saying today. We want to see what steps have been taken.
Obliged, my lord.
Appropriate steps will be taken from this court.
For admission, item number 2.
Lordship, these two matters are likely to take some time. So let the other.
We'll take up the
matter
other
get itself
PL, we'll take it up
Lordships.
after some time. Call up item 4. Item 4 is another, no? Another. Have you filed your affidavit?
For admission, item number 4 to 37.
Worship, the additional AG was directed to file his affidavit with regard to the steps taken to the proposal sent by the department.
Yes.
Worship, that is what
With regard to the,
yeah, manpower,
yes.
administrative staff. Lordship,
Where is the additional AG?
Lordship, besides the proposal sent by us, Lordship, now the department has taken initiative to depute some of the officers and staff. They are already in the college, medical college. They are working from there, Lordship. Around 15 to 20 staff has been taken off from the directorate, from every section, Lordship. Till the recruitment is done, the college should function, Lordship. So we have put up
But we want to see, we want to know what happened to the proposal.
Lordship, yes, that the additional AG would be that.
Where's the additional AG? Who is the additional AG?
Lordship, he is on leave. His file is letter of absence.
Where, please, Lordship? My lord, he is on leave.
Up to
30.
31, 30. We'll list it on first.
Okay.
Tell him to make sure affidavit is filed
Okay.
in terms of the order of 14/12/2022.
Okay, buddy.
Heard MS Nito Learned Counsel for the petition.
Petitioners.
It is submitted that Ms. James Timson, Learned Additional AG, is on leave till 30/31/2023. Accordingly, list this matter on 1st February.
Obliged, Lord.
For admission, item number 2.
There are two cases, Lordship, listed together, item number 2 and 3. Item number 2 will depend upon the outcome of the item number 3, Lordships. Therefore, item number 3 may be taken up first, Lordships. This is with regard to the third amendment of the Nagaland Legislative Assembly Secretariat Conditions of Service.
I'm
Rules.
sorry to interrupt, Your Lordship, just to bring it to the knowledge of Your Lordship. In this case, in 92, Your Lordship, I have, in fact, even the private respondent have raised the issue, preliminary objection on maintainability, Your Lordship. Of course, I leave it to Your Lordship if Your Lordship wants to hear both.
On what grounds?
On
Maintainability?
maintainability, Your Lordship. Now, on the legal status of the petitioner That is one. Second, on separation of facts. Thirdly, Your Lordship, on locus. Your Lordship may kindly appreciate that the challenge in this writ petition is not a policy decision or an order issued under Article 162 of the Constitution of India. What the petitioner is challenging by filing this writ petition is the rule, a piece of legislation, Your Lordship. Now, therefore, locus is very important. So, third and the fourth, Your Lordship, the validity of the affidavit. So, on the four issue I have raised, Your Lordship.
That point may be kept open,
Yeah,
Lordship.
please, Lordship.
And then they can make
My respectful
submissions.
submission is that, my lord, to save time, if lordship kindly allow us to raise the maintainability, and when thereafter, if this honorable court desires that the merit also has to be heard, well, the learned counsel for the petitioner submits, he can submit on both the merit as well as the maintainability. Because if he submit on merit, then we reply on merit and maintainability, then again he will reply on maintainability, it may prolong. So our respectful submission, and we have strong ground on the maintainability, so kindly allow us to raise the maintainability. Let him reply on merit as well as the maintainability thereafter.
And the last
That will save time.
It was
That is
heard
our
for about
submission.
2 days. And thereafter, order has also been passed by this honorable court, directing the counsel for the respondent number 1 to produce the records also, Lordship. It was. So, Lordship, let me open up my case, and then after hearing, let that preliminary objection be kept open. That is her right, Lordship. And then Lordship can dispose of these 2 matters.
My lord, I will again, lordship. Kindly allow us to submit on maintainability first. Let him reply
Lordship,
on
it
both
will
the
be all the
maintainability and
same.
merit.
So why not we proceed accordingly, Lordship, systematically? I will try to satisfy your lordships how this writ petition is maintained.
We'll hear on maintainability.
Lordships. Okay, please, your lordships. Lordship is hearing on the maintainability first.
No. No, on maintenance.
Lordship, by not hearing on the ground of maintainability, how they will be prejudiced, Lordship? Because they will be heard after I make submissions, Lordships. But if my petition is dismissed without hearing me on merit, only on the ground of maintainability, then it will prejudice me. But in no way they will be prejudiced for hearing the case on merit, and thereafter, it's not that they are denied, they are deprived to make submissions with regard to the maintainability of the writ petition. Lordship. So I may be allowed to place a summary of the case, how this writ petition has been filed, Lordships.
And when you open up your case and the maintainability issue arises, then again we'll have to go back to them.
Lordship, after they submit on the ground of maintainability, I have to make submissions also. So it will be all the same. That's why, Lordship, for the end of justice, what is the harm in hearing this case on merit? I will first give a brief background. Thereafter, Lordships can decide.
We'll do one thing, Mr. Siti Jamir.
Lordships.
We'll hear on maintainability, plus after that, we'll allow you on merits as well as reply on maintainability.
Lordship.
Both sides. We'll give you sufficient time.
My surprise. May I please, Lordship? Lordship, as I've submitted preliminary objection in my affidavit, I have raised on 4 grounds. That is, firstly, on the legal status of the petitioner number 1. Secondly, on separation of material facts. Thirdly, on locus. And fourth, on validity of affidavit. Now, on the first, coming to the first ground, on the legal status of petitioner number 1, may I take your lordship to the writ petition, paragraph 1. I'll just read out 3 lines, page 4. May I read out? Writ petition, paragraph 1. The first 3 lines, that the petitioner number 1 is a registered association known as the Nagaland Assembly Secretariat Staff Association, herein referred to as NASSA, represented by its president, such and such. Now, though this statement has been made, your lordship, no documents has been annexed by the petitioner to support this statement, your lordship. And your lordship, there's a distinction in pleadings under CPC and writ petition, your lordship. In a plaint, only facts are to be pleaded under CPC. But in a petition under Article 226, your lordship, not only the facts, but even evidence in proof of such facts is also required to be pleaded and annexed, your lordship. Now, except for making the statement that petitioner number 1 is a registered association, no documents have been annexed, your lordship, to prove these facts. Now, petitioner, they have filed reply affidavit. In the reply affidavit,
1 minute.
reply affidavit, your lordship has got
Mr.
it.
TB, you are for respondent number?
I am for respondent number 1. This-
What is that affidavit? Respondent number 1, affidavit? Proceed it. No.
Reply affidavit.
Reply affidavit
Okay, reply affidavit now.
on behalf of petitioner. Reply affidavit on behalf of petitioner.
Against respondent 1 and 2.
Lordship, respondent number 1. Lordship has got it. Lordship, may kindly turn to page 12. There is annexure 1. Type pages at page 13.
Page 12.
Page 12. Type page, clear copy is there, page 13. This is a certificate of registration.
Affidavit. On behalf of, against respondent 1.
1, Lordship.
This dated
Here, your Lordship.
18 July.
I received it on 18/7/2022. 18/7.
Yes. Certificate of registration.
Yes. 12 is there. Type copy is at page 13, your Lordship. There is a certificate of registration which is dated 15th of March 88. Issued by ex-officio Registrar of Society, Director of School Education. May I read out? Certificate of registration number such and such in the office of the Registrar of Society in Nagaland, Kohima, under Registration of Societies Act 1860 as amended by such and such. In the matter of the application of such and such for the registration of society at Kohima in the district of Kohima, I do hereby certify that pursuant to section 3 of the registration, section 3 of the Registration of Society Act as amended by such and such, the center has been registered in my office as society under the title Nagaland Assembly Secretariat Staff Association, your lordship. Now, in the reply affidavit, the petitioner has annexed this certificate of registration which was issued under Section 3 of the Registration of a Society Act, issued in the year 1988, Your Lordship. 1988. Now, may I take Your Lordship to the Society Registration Act, which is Nagaland Code Volume 8. No, I have given the list of book, Your Lordship. It's okay. Kita masuk ni lagi, ni lagi. Oh, ini lagi.
The third amendment is back.
Section 3, Your Lordship has got it. Now, may I take Your Lordship to Section 3A, capital A, Roman 1. May I read out? A certificate of registration issued under Section 3 shall remain valid for a period of 2 years from the date of issue, and the certificate of registration issued before the commencement of this act shall be valid for 2 years from
Where are you reading, Mr. Chief?
Section 3A.
Lordship, the guy is the amendment. I have flagged.
The Third Amendment Act 2009. The act has gone several amendments, Your Lordship.
This is first amendment.
The Third Amendment,
Lordship, kindly see the flag, Lordship.
Okay.
The-
No, but this was amended in 2009,
2009,
2008.
2008,
Certificate was issued in 1988.
1988.
Yes.
Now, even as per this, even after issuance of this, just 2 years.
Okay.
Lordship. Valid for a period of 2 years. All certificate of registration shall be renewed within 3 months, because if the second part, Your Lordship, 3-1, now issued before the commencement of this act. Now, supposing if the certificate of registration which was issued to the petitioner was in the year 1988, now shall be valid for 2 years. Am I clear, Your Lordship? Now, all certificate of registration shall be renewed within 3 months of the date of expiration of the validity period as specified in the foregoing subsection, Your Lordship. In other words, Your Lordship, unless the certificate of registration issued in favor of the petitioner is renewed within the time as stipulated in the Act, Your Lordship, its validity expires, Your Lordship. It is no more a registered association, Your Lordship. Now, as I've submitted, Your Lordship, except for the registration certificate issued in the year 1988, there is nothing on record to show as regards renewal of the registration by the association. No record. So by operation of law, Your Lordship, petitioner number 1 is already deregistered. It is no more a registered association. It is no more a legal entity. Therefore, a writ petition filed by an unregistered association and non-entity is not maintainable, Your Lordship. Now, may I refer to the case law? First citation, it has come, the books. 1988 for SSC 534. Whether the
Books have come out. Okay, you proceed. Books are coming.
I'm relying on. I'm
Para?
relying on para 13, Your Lordship. This is Bharat Singh and others versus State of Haryana and others. Para 13, Your Lordship may just note down 9th line from the bottom. I will just read out the relevant point. In this context, it will not be out of place. No. No, it's okay. May I just read? It's okay. No, I may just read out. So in this context, it will not be out of place to point out that there is a distinction between a pleading under the Code of CP's Civil Procedure Code and a writ petition or a counter affidavit. While in a pleading, that is a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in counter affidavit, not only facts, but also the evidence in proof of such facts have to be pleaded and annexed. Your Lordship. Now, on registration, I am referring to 10, Volume 2, GLT 673. Paragraph, Your Lordship, para 6, 9, 10, and 18. I will read out only the relevant portion, Your Lordship. The respondent herein registered this writ petition by raising a preliminary objection in their counter affidavit that the petitioners have no locus standi to file the writ petition, and therefore the writ petition is not maintainable in fact and law. Now, para 8. I have not read the whole paragraph, only the relevant, Your Lordship. Now, the primary issue before us is whether, at the threshold, without going into the merit of the writ petition, it can be disposed of by concentrating on the issue of maintainability. To answer this issue, we like to pause whether the writ petitioner herein has locus standi to file the writ petition challenging the virus of the amended rules. Here also the same issue, Your Lordship. A new rule in the rules amended as indicated in the foregoing paragraphs. To answer this issue, we must go into the facts as averred in paragraph 1 and 2 of the writ petition. Now, in the fact that the petitioner association still remains an unregistered association can be located, spotted from Annexure 1 of the counter affidavit filed by respondent number 1 to 3. Annexure 1 is the communication of the Register of Society Meghalaya Shillong dated such and such, addressed to the Commissioner of Excise Meghalaya Shillong, wherein it has been indicated that for want of certain document as indicated therein at serial number 1 to 3, Shillong Wine Dealers Association could not be registered as Meghalaya Wine Dealer Association as desired by the applicant. Now, para 9. Now the question before us is whether the petitioner, Meghalaya Wine Dealer Association, can assume the character of either a juristic person or legal person without registration and can bring the writ petition challenging the virus of the amended and new rules. Meghalaya Wine Dealer Association is an association of the licenses who obtain such licenses for running liquor business in the state of Meghalaya. Each individual license holder, if is aggrieved by any action of the government or the respondent authorities, can bring an action under Article 226 of the Constitution, but individual license holder cannot file writ petition for each and every license holder unless they form an association and such association is registered. When the association is registered under the relevant act, such association assumes the character of a juristic person or a legal person which may sue or may be sued. This Meghalaya Wine Dealer Association, admittedly being not a registered society under the Meghalaya Society Registration Act, it cannot file writ petition against the respondent seeking relief as indicated in the writ petition, and in that situation, the writ petition so filed by such unregistered association would not be maintainable. Legal personality means person who are registered under the law as person being capable of exercising right. This is para 10, or having duty to have local standard to move writ application. Individual person aggrieved by any action or inaction on the part of the state or the authority under Article 12 or Article 226 of the Constitution of India, which infringes or its right or has been prejudicially affected by any order, can move the writ application. Similarly, partnership, firm, company, body, corporate, authority created by and under the statute can file a writ application if their rights are affected. Since Meghalaya Wine Dealer Association cannot be branded either as legal or juristic person for want of registration under the Meghalaya Society Registration Act, it has no local standard to file writ application, the same being not fall within the meaning of the person aggrieved. Now, para 18 is, in the result, Meghalaya Wine Dealer Association being not a registered association, under the statute, we are of the considered view that this writ petition is not maintainable. We are therefore constrained to dismiss the writ petition. No cost, Your Lordship. Now, next case which I would like to place before Your Lordship. This is also an unregistered association, Your Lordship. This is 2006. 11 SCC 731. Paragraph, Your Lordship, paragraph 5, 8, 18, 37 to 39, 42, and 97, Your Lordship. These are short paragraphs. I'll read out only the relevant paragraph, Your Lordship. Paragraph 5. I'll be reading out only the relevant paragraph, Your Lordship. The Karnataka Urban Water Supply and Drainage Board Act such and such was enacted to provide for establishment of a water supply and drainage board and the regulation and development of drinking water and drainage facilities in the urban area in the state of Karnataka. The board, with previous sanction of the government of Karnataka, framed the Karnataka Urban Water Supply and Drainage Board Service, cadre and recruitment regulation. An amendment to serial number 1 of the schedule to the regulation was introduced. Here also one schedule is being challenged by the board, whereby even the chief engineers of the board were made eligible for appointment to the post of managing director. Response number 1 is the Karnataka Urban Water Supply and Drainage Board Employees Association, represented by its president, such and such. Now, response number 1, the Employees Association. This is the association, filed writ petition in the High Court of Karnataka challenging the appointment of one such and such as managing director of the board. That is para 8. The employees union filed an amended version of the writ petition before the High Court, also challenging the above mentioned amendment to the regulation, which relates to making of a provision of appointment of chief engineer of the board as its managing director. Para 18. Mr. P.P. Rao, such and such, made elaborate submission on facts and law with reference to the pleading and actual judgment and relevant provision of the Act. He made submission on the following issue. 1. Writ petition as framed not maintainable at the instance of an unregistered trade union. 2. Locus of the writ petitioner employees union. Now, may I take your lordship to para 37. These are short paragraph only. So that preliminary objection has been raised on locus and on unregistered association. Para 37. The writ petitioner union made a false averment that it is a registered trade union, just like paragraph 1 in the writ petition, to which I have drawn your lordship attention to. That the writ petitioner union made a false averment that it is a registered trade union. That itself, in our opinion, is a ground to dismiss the writ petition, your lordship. Yeah, my second objection will be, preliminary objection will be on suppression of facts. The writ petitioner has made an averment to the following effect in the writ, in his writ petition.
For deregistration. A society which fails to register shall be deregistered. There should be an order of deregistration. Whether this is the
This amendment act, para 3A,
Yes.
clause 5. Just read it. Section 3A,
Your Lordship,
Section 3A, clause 5.
it shall be deregistered. It's very clear.
So there should be an order, isn't it? Deregistering the society.
Now, when the act itself provides that, like, failure, if it fails to renew its registration, it shall be deregistered. Whether such notification will be necessary, Your Lordship.
But we are of the view is that, Mr. TV,
Yes,
clause 3A, subclause 5,
Lordship.
a society which fails to renew its registration
Yes.
shall be deregistered.
Yes.
Meaning thereby that there should be an order deregistering the society. That is what,
Yeah, but in my respectful submission, Your Lordship, that is why I've said by operation of law, it's already deregistered.
By operation of law.
Yes, because the act provides so. So that is why I've submitted, Your Lordship, by operational law, it stands deregistered, Your Lordship. So no separate notification is required. Now, may I continue, Your Lordship? I'll just start from para 37. The writ petitioner union made a false averment that it is a registered trade union. That itself, in our opinion, is a ground to dismiss the writ petition. The writ petitioner has made an averment to the following effect in this writ petition, which is also reflected in the order passed by the High Court in the writ petition, which runs thus. The petitioner is a registered trade union of employees of the second respondent. I think by now the book should have reached. I have submitted the list of books earlier.
What happened? Where's the library?
Anyway, the petitioner is this is what the High Court recorded in the order. The petitioner is a registered trade union of employees of the second respondent, Karnataka Urban Water Supply and Drainage Board, constituted under the Karnataka Water Supply and Drainage Board here near such and such. In the writ petition filed by the respondent number 1 and 2, their locus standi to challenge the appointment of the appellant was asserted in the following word. The petitioner association is a trade union registered under the Trade Union Act such and such. Now, I'll just read out the relevant portion from para 8. These averments were established to be false, just like in the present case, Your Lordship. The registration of the first respondent under the Trade Union Act has been cancelled as early as on such and such. It is not a registered and recognized union, Lordship. Now, para 40.
40.
Para 40. In the instance case, the Employees Association approached the High Court with unclean hand. The employees who approach the court for such relief must come with frank and full disclosure of facts. If they fail to do so and suppress material facts, their application is liable to be dismissed. The Constitution Bench of this court in Narendra such and such held that if a wrong or misleading statement is deliberately and willfully made by a party to a litigation with a view to obtain a favorable order, it would prejudice or interfere with the due course of judicial proceeding and thus amounts to contempt of court. It is thus crystal clear that the employees union have approached this court by suppressing the material facts and has snatched an order on the basis of wrong averment when the employees union had no locus standi to maintain the writ petition on the date relevant in question. The court cannot grant any relief to a person who comes to the court with unclean hand and with a mala fide intention or motive. The writ petition filed by the employees association is liable to be thrown out on this single factor, though it is eminently a free case of awarding exemplary cost. Considering the employee's financial aspect and taking a lenient view of the matter, we are not ordering any cost. Now, para 97, last para. In the result, the petitioner, in the writ petition response number 1 hearing, which is not a registered association under the Trade Union Act, cannot maintain the writ petition. So accordingly, the writ petition was dismissed, Your Lordship. Now, here also, Your Lordship, as I've stated, though in paragraph 1 of the writ petition, a categorical statement has been made that the petitioner number 1 is a registered association. No documents have been annexed in support. In reply affidavit, they have annexed the certificate of registration, which was issued way back in the year 1988. There is no supporting documents to show that their registration was renewed. So by operation of law, it is already a deregistered association. So it is no more a legal entity, and therefore the petition number 1 has no locus. So the writ petition filed by petitioner number 1 is not maintainable. That is one. Second, Your Lordship, on separation of facts. On separation of. Now, Lordship, in the first 3 lines which I read out, statement has been made that society is a registered association, petition number 1, and then it has been filed by the president of the association. Para 1, page 4 of the writ petition, Your Lordship, 4th line, said the president. Lordship. Now, in my humble submission, Your Lordship, being the president, he is fully aware of the facts that by operation of law, their association is deregistered, is no more a registered association. But these facts have been suppressed, which material facts have been suppressed. So petitioner number 1 did not approach this court with clean hand. From the conduct of the petitioner number 1, being not honest, Your Lordship, in approaching this court. And Your Lordship, dishonesty should not be allowed to bear fruit, Your Lordship. And entertaining this petition at the instance of petitioner number 1 will amount to what? Allowing this honesty to bear fruit, which is not permissible, Your Lordship. Now, in this connection, I would like to refer to the case law, Your Lordship, which is reported in 2008, volume 12, SCC. On suppression of facts. 2008, volume 12, SCC 481, para 34, 35, 36, 38, and 39. Yes, K.D. Sharma's case, Your Lordship. Para 34, Your Lordship has got it. May I read out? The jurisdiction of the Supreme Court under Article 32 32 and of the High Court under Article 226 of the Constitution is extraordinary, equitable, and discretionary. Prerogative writs mentioned therein are issued for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hand, put forward all the facts before the court without concealing or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of relevant and material facts, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merit of the claim. Para 35. The underlying object has been subsequently stated by such and such in such and such. It has been for many years the rule of the court, and one which it is of great importance to maintain, that when an applicant comes to the court to obtain relief on an ex parte statement, he should make a full and fair disclosure of all material facts. It says facts, not law. He must not misstate the law if he can help it. The court is supposed to know the law, but it knows nothing about the facts, and the applicant must state fully and fairly the facts, and the penalty by which the court enforces that obligation is that if it finds out that the facts have not been fairly and fairly stated to it, the court will set aside any action which it has taken on the faith of the imperfect statement. A prerogative remedy is not a matter of course. While exercising extraordinary power, a writ court would certainly bear in mind the conduct of the party who invokes the jurisdiction of the court. If the applicant makes a false statement or suppresses material facts or attempts to mislead the court may dismiss the action on that ground alone and may refuse to enter into merit of the case by stating, "We will not listen to your application because of what you have done." The rule has been evolved in the larger public interest to deter unscrupulous litigants from abusing the process of the court by deceiving it. 38. The above principle has been accepted in our legal system also. This is 1039. If the primary object as highlighted in precedent income test is kept in mind, the applicant who does not come with candid facts and clean breast cannot hold a writ of the court with soiled hand. Suppression or concealment of material facts is not an advocacy. It is a jugglery, manipulation, maneuvering, or misrepresentation which has no place in equitable and prerogative jurisdiction. If the applicant does not disclose all the material facts fairly and truly, but states them in a distorted manner and mislead the court has inherent power in order to protect itself and to prevent an abuse of its process to discharge the rule nifty and refuse to proceed further with the examination of the case on merit. If the court does not reject the petition on that ground, the court will be failing in its duty. In fact, such an application requires to be dealt with for contempt of court for abusing the process of the court, Your Lordship. So, in my respectful submission, Your Lordship, from paragraph 1 itself of the writ petition, and then when we see the certificate of registration of the association, it is clear on the basis of record that the petitioner association is no more a registered association, but these facts have been suppressed in the writ petition. So as per the law laid down by the Honorable Supreme Court, Your Lordship, or if on ground of suppression of facts itself, Your Lordship, this petition is liable to be dismissed, Your Lordship. Now, the third ground, Your Lordship.
Yes.
The third ground, Your Lordship, on the locus of the petitioners. Now, what is being challenged in this petition? May I take Your Lordship to page 45 of the writ petition? Lordship has got it?
Yes.
In excess of the power conferred by clause 3 of Article 187, Your Lordship, I'll be referring to this next, of the Constitution of India, the Governor of Nagaland, in consultation with the Speaker of the Nagaland Legislative Assembly, hereby makes the following amendment in the Nagaland Legislative Assembly Secretary such and such rules as amended 2012. Now, what is being challenged is this notification by which the service rules has been amended, Your Lordship. Now, Your Lordship. Next, may I take Your Lordship to Article 187 of the Constitution, because this rule has been amended in exercise of power under Article 187 of the Constitution, Your Lordship.
We are entering into the merit now.
No, Your Lordship. No, just purely, it will be purely question of law, Your Lordship, not on merit.
No, Mr. See, one thing, so far, okay, if we accept, assuming we accept that the registration of the society is no more valid,
No.
we accept, suppose. What about the other members, who are the petitioners and who are not members of that association?
Lordship, I'm coming to that. I'm coming. The others are there as petition number 2, 3, and 4. Petition number 1 is the association. There are other petitioners, 2, 3, and 4. I'll be coming to that. Now, here, Your Lordship, at the beginning, before I started my submission, I went to the ground. I've already brought to Your Lordship knowledge that what is being challenged in this writ petition is not a policy deviation, nor any order or notification issued under 162. Now, in order to challenge the rule piece of legislation, Your Lordship, the petitioner has to first establish his locus. I'll satisfy Your Lordship. I have case law on that. Now, locus, to go into the locus, what is being challenged, we'll have to see this amendment. Supposing which portion, which paragraph was amended, whether petitioner has locus to challenge it. I'll satisfy Your Lordship with case laws, Your Lordship. So I'm not going on merit. I'll just read out the paragraph by what amendment has been brought to the service rule and whether petitioner has locus to challenge it. Because now, Your Lordship, there is always presumption of validity constitutionally of a statute. Presumption is there. I'll be placing the case laws, Your Lordship. Now, legislation can be challenged only on 2 grounds. Legislative competence. Petitioner is not challenging that. Petitioner is not questioning the legislative competence. 187.3 under Article 187.3, yes, governor has power, fine. Because that is perimeter to Article 309, 187.309 for civil secretariat, rules are free. For assembly secretariat under 187.3. Now, these are same. So this is a piece of legislation, and legislation can be challenged only on 2 grounds. First, on legislative competence. Second, Your Lordship, violation of fundamental rights. Now, petitioner has to show that he has a locus to challenge this, because by bringing this amendment, his fundamental right has been in fact infringed. So I'm not going to the merit. So locus. No. Now 187, just perimeter to 309. For that only, if Your Lordship is satisfied on that, I will not take Your Lordship to 187.3, Your Lordship. Now, anything under 187 or proviso 187.3, like 309 and proviso 309, these are piece of legislation. These are rules. Now, in order to challenge, now who can challenge? Your Lordship. May I take Your Lordship to AIR 1964 Supreme Court? 173. Now, who can challenge? I am coming.
AIR?
AIR 1964, Supreme Court 173. Para 8, Your Worship. So here I am coming on the locus.
AIR 1964.
Supreme Court 173. Para 8, Mohan Chaudhary.
Who's flicking this? She doesn't know which one is the appropriate one. She's flicking on the statutes. Yes.
Your Lordship, this is by a constitutional bench, Your Lordship. This is by a constitutional bench. Para 8, Your Lordship. Just read out the fourth line. In order that, Your Lordship has got it, in order that the court may investigate.
Yeah.
So I'm not going to the merit, Your Lordship. Before the court investigate, questions the validity of a piece of legislation. Before the court examines, in order that the court may investigate the validity of a particular ordinance or an act of a legislature, the person moving the court should have a locus standi. If he has not the locus standi to move the Supreme Court, the court will refuse to entertain his petition questioning the virus of the particular legislation, Your Lordship. Now, this is clear itself, Your Worship. Now, petitioner first has to establish his locus standi, that is one, before the court examines the validity of the rule. Second, Your Worship, on what ground? Legislation or rule can be challenged. On what ground legislation or rule can be challenged, Your Worship? For that, may I refer to 2014, 8 SCC 682. This is also by a constitutional bench. 2014, volume 8 SCC 682, para 49. Para 49. Lordship has got it? May I read out? Where there is a challenge to the constitutional validity of a law enacted by the legislature, the court must keep in view that there is always a presumption of constitutionality of an enactment, and a clear transgression of constitutional principle must be shown. The fundamental nature and importance of the legislative process needs to be recognized by the court, and due regard and deference must be accorded to the legislative process. Where the legislation is sought to be challenged as being unconstitutional and violative of Article 14 of the Constitution, the court must remind itself to the principle relating to the applicability of Article 14 in relation to invalidation of legislation. The two dimensions of Article 14 in its application to legislation and rendering legislation invalid are now well recognized, and these are discrimination based on an impermissible or invalid classification, and excessive delegation of powers, conferment of unchannelized and unguided powers on the executive, whether in the form of delegated legislation or by way of conferment of authority to pass administrative orders. If such conferment is without any guidance, control, or check, it is violative of Article 14 of the Constitution. The court also need to be mindful that the legislation does not become unconstitutional merely because there is another view or because another method may be considered to be as good or even more effective, like any issue of social or even economic policy. It is well settled that the court do not substitute their views on what policy is. On this, Your Lordship, kindly continue go to my next citation, Your Lordship, which is 1996. Volume 3, SCC 709. This is by a three-judge bench, Your Lordship. 1996, 3 SCC 709, para 43. I'll read out only one paragraph. Para 43, Your Lordship. Page 737.
Yes.
May I read out? 7 line from top. Before, however, we refer to the holding in the said decision, it will be appropriate to remind ourselves of certain basic proposition in this regard. In the United Kingdom, Parliament is supreme. There are no limitations upon the power of Parliament. No court in the United Kingdom can strike down an act made by Parliament on any ground. As against this, the United States of America has a federal constitution where the power of the Congress and the state legislatures to make law is limited in two ways, which the division of legislative power between the state and the federal government and the Fundamental Rights, Bill of Rights, incorporated in the Constitution. In India, the position is similar to the United States of America. The power of Parliament, or for that matter, the state legislature, is restricted in two ways. A law made by Parliament or legislature, I'm relying on this, a law made by Parliament or legislature can be struck down by court on two grounds and two grounds alone, which lack of legislative competence and violation of any of the fundamental rights guaranteed in Part 3 of the Constitution or any other constitutional provision. There is no third ground, Your Worship. Now, Your Lordship, here in the first case, so far as petition number 1 is concerned, is not a registered association, no more, already deregistered, it has no locus. Secondly, Your Lordship, now only an aggrieved person can move the court. Now, before the petitioner goes into the merit, the petitioner has to satisfy this honorable court that he is aggrieved by this in order to establish his locus. How is he aggrieved by this? By these amended rules. How is he aggrieved? Petitioner has to satisfy this honorable court before going into the constitutional validity of the rules on violation of fundamental rights, because the petitioners, they are not questioning the legislative competence, Your Lordship. And the petitioner has to satisfy Your Lordship that these rules, amended rules, is unconstitutional so as to give them the locus, Your Lordship. Now, therefore, in order to ascertain whether the petitioner has locus, Your Lordship, now, may I refer, we'll need to examine who are the members of the association first. Who are the members of the association? Now, may I take Your Lordship to para 1 of the writ petition? Who are the members of the writ petition?
Yes.
Now, petition number 1 is a registered association known as such and such, represented by its president, such and such, such and such. The petition number 2, 3, and 4 are not member of the NSA, but they are equally affected by the arbitrary action of the respondent. The petitioner number 2 is the senior-most additional secretary. Petitioner number 3 is the senior-most joint secretary. And the petitioner number 4 is the second senior-most secretary. In other words, subject to what the senior counsel for the petitioner will say, the petitioner, the members of the association, petition number 1 association, are all from below the rank of joint secretary. So from the rank of joint deputy secretary and below. Right? Now, how are they affected by this amendment? May I take Your Lordship to page 45? the amended rules, the notification. Your members of the association are all from the rank of deputy secretary and below. Because pages 2, 3, 4 are additional joint. Now, page 45, Your Lordship. Now, what is being challenged? Para 2 of the notification. Rule 6, may I read out? Rule 6, para 2 of the word, your Lordship has got it, page 45.
Yeah.
Short title and commencement is there. 1, 2. Lordship has got it. Now, in Rule 6, para 2, the word for the period not exceeding 3 months shall now be read as for a period not exceeding 6 months. Now, may I take your Lordship to the rule, which is at page 19. Lordship has got it. Now, function of the board, para 6. Now, para 2 has been amended. Here, your Lordship, it is 3 months is there. Provided that it shall not be necessary to create such temporary post, creation of temporary post, as the speaker may, provided that it shall not be necessary to consult board, finance department, or such and such in a grade, subordinate grade 4 staff for a period not exceeding 3 months. Instead of 3 months, it has been extended to 6 months by this amendment. So, this is a temporary post, creation of temporary post. Now, how is the members of the petitioners association are aggrieved so as to establish their locus? That their fundamental rights have been affected by this. I'm not going to the merit, Your Lordship. What are the rules that are being amended, Your Lordship? I'm just taking Your Lordship to do. Now,
This 3 months and 6 months relates to which post?
the grade 4 post, it is mentioned here, Your Lordship. Grade 4 staff for a period. And Your Lordship, this is only a temporary post. By creating that, by extending that period, those who are employed on on temporary basis from 3 months to 6 months, how is the right of the petitioners, members of the petition association affected? The fundamental rights, Your Lordship. So that they can come, they can be called as aggrieved person, so as to establish the locus. Now, do we have a locus? Because our fundamental rights have been affected, Your Lordship. This is purely a temporary provision, Your Lordship. And as I've said, Your Lordship, in the pleading, the petitioner has to show some mixed statement that by extension of the tenure from 3 months to 6 months, the temporary appointment, our rights have been affected in this manner. In the whole writ petition, Your Lordship, the petitioner is completely silent as to how their fundamental rights or constitutional rights have been affected by this. So whether they can be called as aggrieved person, so as that to show that, to establish that they have a locus to question the constitutional validity of the rules, Your Lordship. And as I've said, since when it comes to legislation, presumption is always there in favor or as regards constitutional validity of a legislation. Now, burden is on the petitioner to prove. The petitioner is totally silent, Your Lordship. Now, therefore, Your Lordship, the petitioner number 2, I'm saying, the petitioner number 1 has no locus to challenge this amended Rule 6, para 2 of the rules, Your Lordship. Similarly, Your Lordship, coming to petition, now I'm coming to petition number 2, 3, and 4. Lordship has already raised that issue. There are other petitioners. Now, they are from the rank of Joint Secretary and above. how are their rights affected? How are they aggrieved to be filing this writ petition, challenging this amendment? They have no locus, Your Lordship. Now, the second challenge, Your Lordship, para 3 of the notification, which is at page, again, I'll take Your Lordship to page 45. Para 3, Lordship has got it. Rule 9. Rule 9 shall be replaced as follows. Recruitment to the post or class of posts may be met by any one of the following methods, namely promotion, deputation, direct recruitment, and short-term contractual agreement. This is newly added, Your Lordship. May I take Your Lordship to page 19, page 19, rule 9 is there, method of recruitment. Lordship has got it. So promotion, deputation is there. C, by direct recruitment is there. And D, it has been added by short-term contractual appointment. This is newly incorporated, Your Lordship. Now, Your Lordship, how is the petitioners aggrieved by this? This is a method of recruitment, Your Lordship. This is solely within the domain of the employer, Your Lordship. Whether it is contractual appointment, deputation, or whatever, Your Lordship. The petitioner has to, in order to establish a locus, the petitioner has to satisfy, Your Lordship, that they are aggrieved, they are aggrieved person because their fundamental rights have been affected by this, Your Lordship. Whole petitioner is completely silent as to how the amendment to this Rule 9 has affected their fundamental right, Your Lordship. Now, similarly, Your Lordship, the same, I advance the same submission in respect of petition number 2, 3, and 4, Your Lordship. Even they have no locus to challenge the amendment to these rules, Rule 9, Your Lordship. They have no locus. They cannot be called to be they cannot come within that phrase, aggrieved person, so as to invoke the jurisdiction under 226 of the Constitution. And that also questioning the constitutional validity of a piece of legislation, Your Lordship. Now, the third challenge is para 4. Para 4 of the notification, Your Lordship. In Rule 10, may I read out? Under the caption, streamlining of existing cadre, the existing clause A and B are replaced as follows. A, there shall be no intertransferability between the cadre schedules up to the rank of Joint Secretary. There shall be no distinction of cadre above the level of Joint Secretary in the assignment of duties, distribution of work, and for all other service matters, Your Lordship. Now, so for this, Your Lordship, is from at the level of Joint Secretary and above, Your Lordship. Petitioner number 1, association, they have no locus. 1 to the other, Rule 6, Rule 9, they have no locus. Rule 10, petitioner association, they have no locus, because this is not, it does not affect its members, Your Lordship. Because Rule 10 relates to Joint Secretary and above, Your Lordship. Now, here, Your Lordship, in my respectful submission, streamlining, structuring, restructuring, these are all within the domain of the employer, Your Lordship. What this Rule 10 by amendment, what it does is simply restructures the cadre, streamlining. So the petitioner has no locus to question the action of the employer, Your Lordship. Just because the employer, they have decided to restructure the cadre, they cannot be said to be, and which is exclusively within the domain the petitioner cannot be said to be, no doubt, some of the officers may be affected, but cannot be a ground to question the constitutionality or validity of a piece of legislation, Your Lordship. Fourth challenge, Your Lordship, is Rule 12 amendment. The fourth Rule 12 has been amended. The amendment, not challenged. What are being amended? Rule 12 is amended, which is at page 46. Lordship has got it. May I read out? Rule 12, under the caption appointing authority, the existing sub-rule is replaced by the following. The secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. Here also, Your Lordship, petitioner number 1 association has no locus. It relates to the post of additional secretary and secretary. It all, by this amendment, Rule 12 only provides for the manner as to how the post of additional secretary and secretary is to be filled up, Your Lordship. And by this amendment, it says that the secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. Now, how is the fundamental rights have been affected by this? What right has been infringed, Your Lordship, by this amendment? So the petition number 2, 3, and 4, so they have no locus. They have no locus to question this because none of the fundamental rights have been affected. They are not the aggrieved person to be approaching this court by filing a writ petition and seeking for relief, Your Lordship. Now, in order to establish a locus, petitioner has to satisfy first that they are aggrieved by this. They are aggrieved. Now, the next amendment, Your Lordship, is at page 46, which is Rule 12. Rule 15, Your Lordship. Para 6. Lordship has got it. Under Rule 15, paragraph such and such is modified as follows. Annual Performance Appraisal Assessment Report, APAR. This provides for APAR, Your Lordship. Earlier it was ACR. Of the preceding 5 years, keeping the average benchmark requirement of very good rating, how APAR is to be rated. And it is exclusively within the domain of the employer, Lordship, whether this court can direct the respondent number 1 how APAR is to be assessed, and how is the petitioner aggrieved by this. Therefore, be it the petitioners association, because APAR will be compulsory for all members of the association as well as for petition number 2, 3, and 4. But they have no locus to challenge this and they are completely silent, as I've said, in the writ petition. Because of this, they are affected in this manner. Their fundamental rights has been infringed. No, they are completely silent in the writ petition, Your Lordship. And I'll repeat, Your Lordship, they are challenging the constitutional validity of a legislation, Your Lordship. Now, Your Lordship, last challenge is Rule 7, Para 7. These are the amendment. Para 7 has been amended. May I read out? Third Schedule A, against serial number 1, column 6, the following shall replace the existing entry. Deputation, officer such and such. Now, what has been added is C, Your Lordship. A serving officer from central government with experience of working as the secretary in any state or union territory legislative assembly secretary. This is added C. And contract newly incorporated.
Who is the Shiju?
The main act, Your Lordship, main act will be at page 28. This is exclusively for the post of secretary, Your Lordship. Lordship has got it. Now column 6. Lordship has got it. Column 6 here in the old act on deputation, that is there, deputation. Now here it has been added the addition part. If your my lord can kindly turn to page 46. This is contract has been added. And next page, Your Lordship, page 47, in third schedule A, serial number such and such, column 7, the following shall replace the existing entry. By promotion from the grade of additional secretary or equivalent has been added. In the assembly, now, Your Lordship, what I would like to apprise Your Lordship is this. By this amendment, what has been provided is the manner in which the post of secretary is to be filled up. Your Lordship, this thing. Now, in my respectful submission, Your Lordship, this is exclusively within the domain of the employer, Your Lordship. Now, in the writ petition, the petitioner has failed to show as to how their right has been, be it fundamental, constitutional, how their right has been affected, Your Lordship. So that being so far as the petitioner association are concerned, they have no locus here in this, because the post relates to the post of secretary only. They are not a member to that. Now, even for petition number 2, 3, and 4 also, Your Lordship, as to how a post is to be filled up, in my respectful submission, is within the domain of the employer, Your Lordship. Now, whether this honorable court can direct the respondent, no, you have to fill up in this way. So that is why I'm saying, Your Lordship, if the petitioner has no locus, so if to challenge the amended rules to notification, Your Lordship. Now coming to my last objection, Your Lordship. The fourth, on the validity of affidavit. Now, why is it necessary that pleading should be affidavit accompanied by a valid affidavit? That has been dealt with by this honorable court and reported in 2014, 3 GLT 430. Para 88. Lordship has got it?
Yes.
May I read out?
Which para?
Para 18, Your Lordship. May I read out? Litigations before our court are decided on the basis of pleadings and evidence which are supported by affidavits. A proper and valid affidavit is thus the foundation of the case superstructure which is adjudicated upon by the court. If the affidavit is found to be defective, or if the affidavit suffers from some basic fundamental mistake, it is bound to affect the case superstructure. Affidavits play a vital role in the dispensation of justice and cannot be taken lightly. Filing of affidavit is not an empty formality, since the outcome of the case is dependent on it. due care and attention has to be given in filing affidavit, Your Lordship. Now, Your Lordship. Now, issues are decided based on pleadings, evidences, and which are supported by affidavit. Therefore, proper and valid affidavit, Your Lordship, is the foundation of the case. This is what has been held by this honorable court. May I take Your Lordship to page 16, the affidavit. Page 16, Your Lordship. Now, para 1, that I am the petitioner and president of Nagaland Legislative Assembly Staff Association. By virtue of my office in the association, the instant writ petition is being filed and represented by the president and the secretary of association. I have been duly authorized by the secretary of the association and the petition number such and such to swear this affidavit. Now, Your Lordship, the affidavit accompanying this writ petition has been filed on behalf of all the petitioners by the president of an entity which, if I may say so, does not exist in the eye of law. Because association is already deregistered by operation of law, so it does not exist in the eye of law. So, but this affidavit is sworn by an entity which does not exist in the eye of law, Your Lordship. Not only that, Your Lordship, even a false statement has been made. Why I'm saying so, Your Lordship? Para 2 of the affidavit. The statement made in this affidavit and in the accompanying petition in paragraph 1 are true to my knowledge. This is a false statement, Your Lordship. Now, therefore, the affidavit accompanying the writ petition, Your Lordship, cannot be accepted as a valid and proper affidavit. Now, Your Lordship. May I refer to one case law, Your Lordship, where the Honorable Supreme Court has held that when the issue of maintainability is raised, that needs to be answered first, Your Lordship, and which is reported in 2003, Volume 7, SEC 410. Para 6. Justice H.K. Sema, Honorable Justice, who was also one of the judges here. Para 6, Your Lordship. May I read out? The respondent then filed a writ petition in the High Court for refund of the amount. On the pleadings before it, the High Court raised 2 questions, which A, whether the forfeiture of security deposit is without authority of law and without any binding contract between the parties, and also contrary to Section 5 of the Contract Act, and B, whether the writ petition is maintainable in a claim arising out of such and such. The High Court instead considered question A and then choose not to answer question B, that is on maintainability. In our view, the answer to question B is clear. It is settled that a dispute relating to contract cannot be agitated under such and such. It has been, now the last second line, thus, on the ground of maintainability, the petition should have been dismissed. So, in other words, maintainability ought to have been taken up first, and on ground of maintainability, the petition should have been dismissed, Your Lordship. Now, just to sum up, Your Lordship, I have raised the question of maintainability of the writ petition on 4 grounds. That is on the legal status of the petitioner, number 1, the association. suppression of facts, Your Lordship, and locus of the petitioner. Why I'm saying why locus is important, because, Your Lordship, at the cost of repetition, I'm saying that what is being challenged here is not a policy decision. It is not an order notification issued under 162 of the Constitution of India, but a piece of legislation. Therefore, locus petitioner has to satisfy the locus, that they are aggrieved by this before before examining by this honorable court the validity, constitutionality, or the virus of the rules, Your Worship. And third, on affidavit. And on all four counts, Your Worship, in my submission, the petition is not maintainable. And on ground of maintainability, the petition is liable to dismissed. And as held by the Honorable Supreme Court, Your Lordship, the question of maintainability needs to be decided first. Much obliged. I rest.
May it please your Lordship. Lordship, I will only supplement the submission of my learned friend, but I would like to add certain important.
Your respondent?
Number three. Lordship, may I kindly see the, Lordship, may I kindly go to
Mr. TB, your respondent 1 and 2.
1 and 2.
Lordship, respondent number 3 was initially not a
I'm the
party.
intervener.
By
I'm
way
the
of filing
intervener,
an
respondent number
application, he has
One
been
and two.
completed by a subsequent order of this honorable court, Lordship.
I'm the intervener, respondent number. Lordship, may I kindly go to the prayer of the writ petition. I won't take much time. Page 14 and 15, my lord. What is the prayer of the writ petition? Thereafter, my lord, I'll read one paragraph, then I'll refer to my affidavit in opposition. I'll not to substantiate my learned friend's submission. I'm in the premises of possit, it is most respectfully prayed that your lordship may be pleased to admit this petition, call for the records, issue rule calling upon the respondents to show cause as to why a writ of mandamus in or any other appropriate writ, order, or direction should not be granted. So prayer is for mandamus. 1. No certiorari. Lordship, may kindly see page 15. The main prayer is page 15, to quash and set aside the imbued Legislative Assembly Secretariat Third Amendment Rules 2022. So, my lord, this is a blanket judgment, blanket challenge to the whole, not to a particular provisions under the Third Amendment rule, but he has challenged the whole amendment, and my learned friend, Mr. DB, has been pointing out whether the petitioner is aggrieved or not, referring to the specific provisions of law. Now, lordship, may come to page 3, who are the petitioners? My lord, the petitioner, page 3, the petitioner number 1 is the Nagaland Assembly Staff Association. Petitioner number 2 is an additional secretary. Petitioner number 3 and 4 are joint secretaries of the department. Now, lordship, may kindly come to page 4. Kindly allow me to read paragraph 1 to the writ petition, subject to repetition, because it is important to my submission. That the petitioner is a registered association known as Nagaland Assembly Secretariat Staff Association, represented by its president, so-and-so, and general secretary. I'm pausing here for a moment. My lord, the members of the secretary, subject to confirmation from the counsel for the petitioners, the members of the associations are officers and staff below the rank of joint secretary in the department, joint secretary under the assembly. And it is represented by general secretary and president. Now, petitioner number 2, 3, and 4 are not members of the NSSA, but they are equally affected by the arbitrary actions of the respondents. The petitioner number 2 is the senior-most additional secretary in the Nagaland Legislative Assembly, and petitioner number 3 is the senior-most joint secretary, and petitioner number 4 is the second senior-most joint secretary in the same department. They are all adversely affected by the illegal and arbitrary amendment of the rules
and the petitioners number 2, 3, and 4 are all eligible for promotion to the next higher post. As such, they are entitled to all the rights and privileges under the Constitution of India and rules framed thereunder. So, my lord, for petitioner number 2, 3, and 4, their main contention is that by their entitlement for promotion to the higher post has been adversely affected by the amendment. That is what they're saying. Some of the primary aims and objectives of the association is to safeguard and further the interests of the association, to represent the grievance of the members on constitutional line and seek redressal by constitutional means. All the petitioners have a common cause and grievance. In as such, petitioners are filing a common writ petition for the ends of justice. Now, my lord, the petitioner number 1, the president and secretary, has purportedly filed this writ petition in their representative capacity as president and secretary. There is no authorization. Lordship, the pleadings you have gone through a page per paragraph 1. There is no authorization by the association to file. Lordship, may kindly see. Usually when an association files a writ petition, it should be specifically mentioned we are represented by such and such, and draw a meeting or such and such, we are authorized by the association to file. So now, Lordship, this is further proof. When your Lordship may kindly see the affidavit at page 16. So kindly allow me to read page 16. May I read, my lord? I am such and such, age 50 years, resident of Lower Janmari, Kohima, do hereby solemnly affirm and declare as follows: that I am the petitioner, the president of the Nagaland Legislative Secretariat Staff Association. My lord, this is important. By virtue of my office in the association, the instant writ petition is being filed and represented by the president and secretary of the association. By virtue of the post he is filing, there is no authorization. I have been, only then authorization comes. I have been authorized by the secretary of the association. My lord, I'll come. I have been authorized by the secretary of the association and the petitioners number 2, 3, and 4 to swear this affidavit on their behalf as well. I am fully conversant and acquainted with the facts and circumstances of the case, and as such, I am authorized and competent to swear this affidavit on behalf of all the petitioners. So, my lord, going through the pleadings at paragraph 1 in the affidavit, petitioner number 1 is not authorized by the association to file. Petitioners are bound by their pleadings. The affidavit says he is authorized by the General Secretary and 2, 3, and 4 to file, not by the association. So, my lord, individually, so that is one aspect of the matter. Now to this, Lordship, you kindly allow me to go through my affidavit in opposition.
Respondent 3.
Ano galis ako? Yan ano yan yung affidavit i-apply. Affidavit i-apply. Ayos. Lordship, lagi natin napindin na yun. Ano galis sa? Ano pa? Lordship, may kindly allow me affidavit. Lordship, may kindly allow me to read paragraph 3 to my affidavit in opposition, page 2. May I read, Lordship? That with regard to the statements in paragraph 1 to the petitioner tonight, the deponent at the outset are raising a preliminary objection on the maintainability of the writ petition. A mere perusal of the amendments in paragraph 1 to the writ petition, it is claimed that the petitioner is a registered association. However, no registration particulars is mentioned and no documents providing that it is a registered association is annexed in the writ petition. It is respectfully stated that Societies Registration Act 1860, as amended, is applicable in the state of Nagaland. Registration Section 3 of the Act of 2008 provides for renewal. In view of the above facts and circumstances, NASA is not a registered association as wrongly claimed by the petitioner. It is also respectfully stated that common affidavit on behalf of all the petitioners are sworn by Mr. Such and Such, representing petitioner number 1. It is respectfully stated that it is an established principle of law that any registered association only a registered association have the locus standi to file a writ petition before this honorable court. Hence, NASA is not a registered association and the present writ petition is not maintainable with regard to petitioner number 1. It is also respectfully stated that since a common affidavit was sworn on behalf of all the petitioners by a representative of petitioner number 1, the sworn affidavit is not maintainable. And accordingly, the present petition with regard to 2, 3, and 4 are also not maintainable in the eyes of law. The deponent further states that the present writ petition is not maintainable against all the petitioners in view of the willful and deliberate suppression of material facts with regards to issue of registration of NASA. They had approached the honorable court without clear mind and clean hands. It is also respectfully states that NASA does not represent the interest of all the stakeholders of the employees of the Nagaland Legislative Assembly Secretariat. Hence, the present writ petition is not maintainable. Now to this, Lordship, affidavit in reply has been filed. By
Affidavit in reply.
on bill against respondent number 3.
Yes.
Now, my lord, paragraph 4. At page 3, may I read, Lordship? That with regard to the statements made in paragraph, my lord, kindly allow me to read paragraph 1 first. That I'm the president of the association. As such, I'm fully conversant and acquainted with the facts and circumstances of the case, and as such, I have been duly authorized, my lord, here again, by the General Secretary to swear this affidavit on behalf of the petitioner number 1. I have been duly authorized by petitioner number 2, 3, and 4 to swear this affidavit on their behalf, as well as such, I am authorized and competent to swear this affidavit on behalf of all the petitioners. Then, Lordship, may kindly turn to page 4, paragraph 4. That with regard to the statements made in paragraph 3, the answering deponent denies the statement and further begs to state that contention of respondent number 1 is misleading, as the petitioners have categorically stated in paragraph 1 of the writ petition that the writ petition number 1 is a registered association under the Registration Act of 1969, and the said registration was duly published in the Nagaland Gazette on 13/1/6/1988. My lord, it appears the affidavit is a copy-paste. Actually, in paragraph 4, it should have been original respondent number 3, but anyway, content is the same. So, my lord, thereafter, my lord, the documents has been annexed, which has been 1988 registration, which is at, my lord, page 13 and 14, the same registration documents of 1988 registration, which my learned friend has relied upon, has been, my lord, included. Now, Your Lordship. Your Lordship may kindly allow me to read subject to 3A once. The amendment, look, the rules. The society registration rule, Lordship, kindly allow me to read it because certain issue has been raised. I would like to clarify all those points. Now, my lord, my first submission. Rule 3A, 1 to 5 has to be read together, not in isolation. That is my first submission. Now, my lord, how the question of operation of law, by operation of law comes, that I would like to substantiate. My lord, 3A1, kindly allow me to read. A certificate of registration issued under Section 3 shall remain valid for a period of 2 years from the date of issued before the commencement of this act. That is one part. So, my lord, any amendment, any registration issued before the rule was amended in the year 2009 by the Third Amendment Act shall remain valid for a period of 2 years from the date of issue before the commencement of this act. That means from the date of original issue, validity has been provided 2 years. The other part is shall be period before the commencement of this act, shall be valid of 2 years from the date of commencement of this act. So it is in two parts. Any registration issued, Lordship, prior to the Third Amendment of 2009, the life period is 2 years. And any registration, any documents registered after 2009 amendment, the life period is also 2 years. So, my lord, it is divided into two parts. So, my lord, upon the expiry of 2 years, unless and until it is renewed, it stands deregistered by operation of law. The operation of law comes under 3A1. Then, my lord, 3A, then all certificates of registration shall be renewed within 3 months of the date of expiration of the validity period as specified in the foregoing subsection, and renewal shall be valid only for 2 years from the date of expiration of the original validity period.
This is
You have the book.
No, Lordship.
Yeah, you can refer to the book. Otherwise, just I think some printing mistake is there in your. I don't know whether you have taken it out.
My lord, page 40, Lordship.
Yeah. 3A1, it's more clear here.
Yes.
Read it, just read it.
May I read from the beginning?
Yes.
Or a certificate of registration issued under Section 3 shall remain valid for a period of 2 years from the date of its issue, and a certificate of registration issued before the commencement of this act shall be valid for 2 years from the date of commencement of this act.
Yes.
So 2 years.
So 2 years after this act.
Yes, 2 years.
After this amendment.
2 years after this amendment. Then, Lordship, may kindly go to the next one. All certificate of registration shall be renewed. The word shall. Within 3 months of the date of expiration of the validity period as specified in the foregoing subsection, and a renewal shall be valid only for 2 years from the date of expiration of the original validity period. So from the date of issue, validity is 2 years. Now, my lord, every application for renewal shall be accompanied, my lord, by a list of members of the managing body elected after registration to the society, and after the renewal of the registration, as the case may be, a renewal fee of 500, which may be varied from time to time by the state government by notification in the official gazette, provided that the registrar may dispense with any of the documents required for renewal if sufficient evidence is adduced providing loss or destruction of such documents. 5. A society which fails to renew its registration shall be deregistered from being a society at the expiration of 3 months from the date of expiration of the validity period, provided that the registrar, for sufficient reasons to be recorded in writing, may allow an application for renewal made not later to be recorded in writing, may allow an application for renewal made not later than 12 months from the date of expiration of the validity period, after realizing a penalty renewal fee along with application which shall be 4 times of the normal renewal fee. So, my lord, if for late a submission after the expiry, if an application is submitted, then, my lord, within 2 months from the date of expiration, after imposition of fee, it can be considered. Now, my lord, Section 5 has to be read in conformity with Section 1. 3.1. Because 3.1 is 3.1, Lordship, and 3.11. 3.1 clearly provides shall be 2 years. Now, my lord, so, my lord, in 3.5 is only talking about, my lord, basically for renewal and those renewal process. And it is also provided here, Lordship. Lordship may kindly see the proviso in that society which has been expired, so registration which is expired, they are entitled for renewal only if not later than one applies within 12 months from the date of expiration of the normal validity period. And if sufficient reasons are given within 12 months from the date of expiry, then after imposing a fine up, which is up to 4 times of the normal renewal fee, Lordship, it can be considered. Now, my lord, parties are bound by their pleadings. In the pleadings, in the affidavit in reply, Lordship, categorical statements I have in the affidavit in reply of the petition. In the red petition, it says we are a registered association. That has been supported by petitioner number 2, 3, and 4 with a sworn affidavit. My lord, because affidavit was sworn with the authorization from 2, 3, and 4. We pointed out the defects in our affidavit in opposition. That no, you are not registered, no document has been annexed. Now affidavit and reply has been filed, which is by respondent number 1, by the president, and with authorization from 2, 3, and 4, and said, no, we are registered, and documents has been annexed. Nowhere it is mentioned that we have applied for renewal, or renewal is under process. Categorical statement, no, we are registered, which is factually wrong. So, my lord, petitioners number 2, 3, and 4 are also party, along with petition number 1 on suppression of material facts. Now, Lordship, this is a judgment by Lordship. This is a petition filed by Nagaland Pre-Service Teachers Association in 2016. Married Lordship. Mr. Takamasa, Learner Counsel, Senior Counsel, appearing on behalf of the private respondents, as well as Mr. T.P. Javier, Learner Senior Additional AG, appearing on behalf of the state respondents on the other hand. My lord, the Learner Senior Counsel for the petitioner prays for withdrawal of the petition. On the other hand, submits that the present writ petition has been filed by suppression of material facts, in that the petitioners association has approached this court with unclean hands, in as much as that on the date when the writ petition was filed, the registration of certificate of the association had already expired on 13/10/2016. Further, at para 1 of the writ petition, the petitioner, knowing fully well that registration had expired on 30/10/2016, had made a specific statement that the petitioners association is a government-registered association. In that view of the matter, both the Learner Counsel appearing for the respondent submits that the withdrawal of the present writ petition is not permissible at this stage, and matter should be disposed of on the issue of maintainability raised by them. After hearing the Learner Counsel for the parties, without expressing any opinion either on the maintainability or on merits, this court permits the petitioner to withdraw this petition without liberty to file afresh. What has happened in this case, if your lordship recollects? The association was initially registered. Then, like the present case, the 2 years validity period was expired. Then they applied for renewal and it was renewed. And with the new renewal certificate, they filed a writ petition on the ground that it is a registered association. However, lordship, what has happened was the writ petition was filed during the intervening period. That is after the expiry of the registration before renewal. Within that intervening period, when it was not renewed, at that particular moment of time, it was filed. So we raised the maintainability like today. And when the maintainability was raised, the then writ petitioner prayed for leave of this honorable court for withdrawal to file afresh. And we objected that they approached the honorable court by suppressing material facts. So they approached the honorable court without clean hands. In that view of the matter, if the petition has to be withdrawn without liberty, accordingly, this order was passed. My lord, it is equally situated with this present. The present case is, if not worst, because here there is no renewal.
Mr. Taka,
Lordship,
just 1 second.
please.
Can we go to the certificate of registration?
Yes, please.
Which is that?
My lord, in my affidavit, page 13 and 14.
In your,
In my affidavit, in the affidavit in reply, at page 13, affidavit in reply, respondent number 3.
in your,
Affidavit in reply. It's there. Type copy at page 14.
where is it?
My lord, type copy is at page 14.
Page 14.
Yes, in the affidavit reply of respondent number 3. May I read, lordship?
Yes,
The
please.
type copy at page 14. Certificate of registration dated 9/3/88 in the Office of Registrar of Societies, Nagaland Registration Act 1860 as amended by Registration Societies Act 1969. In the matter of application of such and such registration of society at Kohima in the district of Kohima, I too hereby certify that pursuant to Section 3 of the Registration of 1860 as amended by Registration of Societies First Amendment Act 1969, the sender has been registered in my office as a society under title Nagaland Assembly Secretariat Staff Association and numbered as RS 2071 of the year 1989 Anno Timono. Aims and objective, the titles and location of the society, once it's registered, shall be final and no demand for alteration will be entertained after registration. No time period is given here.
Yes.
Now, lordship, thereafter you come to 3(1)(a)(1).
Just this.
Yes.
In this certificate of registration, no period of validity is given.
Exactly, lordship.
Correct.
Yes.
So how do you read this certificate
Yes.
of registration with Rule 3A?
Lordship, may kindly see the amendment.
This 3A. All certificates shall be renewed within a period of 3 months of the date of expiration of the validity period as specified in the. Yes.
Okay. My lord, initially there was no time period, but by the
Whether there is time period or no,
lordship.
it will make no difference in view of the amendment.
Exactly, because amendment, by the amendment, the time period of 2 years has been brought into operation. And my lord, whether this honorable court would be bound by the judgment of a single bench, but single bench, this honorable court in PPC 202K of 2016 had the opportunity to deal with this issue. Had the opportunity to deal with this issue, and 2 years expiration issue has been decided by the single bench. Here, my lord, so my lord, by the operation of law, that's why part of the operation of law 3(1)(a), 2 years, once it is over, it is expired. And my lord, 3(1)(3)(a)(5) is only talking about renewal. And renewal also, lordship, kindly appreciate this fact. Renewal after expiration, renewal is possible only if the society apply within 2 weeks, 12 months after expiry, with penalty and with sufficient reasons. Nowhere in the affidavit of the respondent. So, my lord, that is why I'm pointing out. We pointed out the defects in the affidavit that your registration is expired, you have no right. But in spite of that, he reiterated again in the affidavit in reply that, look, we are registered. And lordship, I'm repeating again. Affidavit in the writ petition, affidavit in the affidavit in reply is filed by petitioner number 1 with prior authorization from 2, 3, and 4. So knowing fully well that they are not a registered association, by suppressing those material facts, they filed the writ petition, reiterated again in their affidavit in opposition. So, my lord, 2, 3, and 4 are also party to the suppression of material facts. They are all together in suppressing the material facts, and they are, lordship, bound by their pleadings. Lordship, can you allow me to submit a judgment? 2011, 15 ACC 453, paragraph 5 and 5, 6, and 7, but it's a shortcut. My lord, these are pleadings. Lordship, may kindly say 453. The lordship, I'm reading paragraph 5. Before us today, the learned counsel for the appellant has argued in the writ petition filed by the respondent state challenging the award of a labor court that the only play was against the grant of back which and nothing involved. In support of this submission, the learned counsel has drawn our attention to the writ petition, which has been appended with a paper book. We find that the assertion of the learned counsel is correct. We are therefore of the opinion that the order of the single judge as well as the division bench of the High Court was well beyond the scope of prayers of the writ petition. If the state feel aggrieved by the award of the labor court in toto, there was no impediment in its way to challenge it in its entirety. We feel that a party must be bound by its pleadings. A prayer clause cannot be construed or dubbed as technicality. We are therefore of the opinion that bill deserves to succeed. So my respectful submission, it's a cardinal principle under 226 also, that parties are bound by their pleadings. So, my lord, the statements in the writ petition, in the sworn affidavit, and the reiteration in your affidavit in reply that they are registered association. They cannot go back from there, and they are bound by that pleadings. And on record, my lord, it is crystal clear that it is not a registered association. And also, my lord, it is crystal clear that the petitioner number 1 has not been authorized, but by virtue of his post, file it. Only authorized by General Secretary 2, 3, and 4, not by the association members. We are bound by petitioner as per the pleadings. Now, my lord, on the question of person aggrieved, just to substantiate my learned friend, my lord, I am citing a judgment, 2001 4 ACC 734. I'll read paragraph
2001.
2001 4 SCC 734, paragraph 2. Just to substantiate his submission. Kindly allow me to refer to this judgment. 2001 4 SCC 734. My lord, I'm reading paragraph 2. My lord, it consists of 4 paragraphs only. May I read paragraph 2? My lord, it's a case where an advocate filed a writ petition on behalf of his clients. Now, paragraph 2. Generally speaking, a person shall have no locus standi to file a writ petition if he is not personally affected by the imbued order or his fundamental rights had neither been directly or substantially invaded, nor is there any imminent danger of such rights being invaded or his acquired interests have been violated, ignoring the applicable rules. The relief under 226 of the Constitution is based on the existence of a right in favor of the person invoking the jurisdiction. The exception of the general rule is only in cases where the writ applied for a writ of habeas corpus or quo warranto or filed in public interest. It is a matter of prudence that the court confines the exercise of writ jurisdiction to cases where legal wrong or legal injuries are caused to a particular person or his fundamental rights are violated, or not to entertain cases of individual wrong or injury at the instance of third party where there is an effective legal aid organization which can take care of such cases. Even in cases filed in public interest, the court can exercise the writ jurisdiction at the instance of a third party only when it is shown that legal wrong or legal injury or illegal burden is threatened, and such person or determined class of persons is by reasons of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief. So, my lord, summing up my respectful submission, my lord, whatever my learned friend Mr. Jamir, DB Jamir has submitted, I'm adopting those grounds. That is why I'm not repeating it. But to substantiate his point, Lordship, the present writ petition is not maintainable with regard to petitioner number 1, as well as petitioner number 2, 3, and 4. Now, Lordship, I'm repeating again. Lordship may kindly look into the pleadings and the prayer of the writ petition. It is a blanket challenge. And especially when the association members are all below the rank of Joint Secretary. My lord, much obliged, Lordship.
City will hear you at 2. Now you have just had
Leave it to your lordships.
Yeah. So we'll do one thing. We have single bench also. So we'll hear you for an hour. 2 to 3. Then after 3 we'll have single bench.
Then if it
Lord
spills
Chair,
over, we'll continue tomorrow.
With regard to my reply to the preliminary objections on the ground of maintainability, I will not take much time because concept of law is changing. Earlier, those days, technicalities were so serious, but now that the concept of law is changing, times are changing, attitudes are changing. So I will not dwell much on the maintainability. Yes, they have raised. I will reply with a short submission only, and thereafter I will try to
My lord,
satisfy your lordships on the merit of the case.
my lord, one line I have overlooked. My lord, the arms of this honorable court under Article 226 is long enough to remedy all any injustice. That is an established fact of law. However, that is with the condition. Honorable Supreme Court time and again has put condition. In such situation, the conduct of the petitioners has to be taken into consideration, well weighing whether it will be fair to extend the long arm of this honorable court to do injustice. So the conduct of the petitioners, we are stressing heavily on the conduct of the writ petitioners. Lordship.
So
Sorry
also
for-
the
I
conduct of the
overlooked that point.
respondent's lordship. Lordship, only one point with regard to the rulings which my two learned friends have cited. India is a large country. Every day, Supreme Court is deciding hundreds and thousands of cases. By taking the ratio of those cases which has been delivered and laid down in a different context, which is not relevant to our context, by applying those principles, whether this is relevant to our case. That aspect, Lordship may kindly take note of, because so many citations have been placed. Those are on a different facts and circumstances. Therefore, my only prayer is, Lordship, and my submission would be that each and every case has to be decided taking into consideration of its own facts and circumstances of the case. Whether in our case, those ratios, principles are relevant or not, that may be looked into by your lordships.
You can satisfy us on whether you have renewed your certificate, your registration.
With regard to the registration,
Because in para 1, you have said that it is a registered
till date,
association. It
yes,
is a registered association.
till
So
date,
whether you have renewed or not.
till date, the authority have not cancelled and there is no order cancelling my association. And for that matter, Lordship, under Kansia, there are so many services associations and almost all the associations do not possess this criteria. Lordship. But besides the association, there are 3 other petitioners who has filed in the individual capacity,
That we have
Lordships.
taken note.
Lordships. Xerox tampak. Jambar deh, cek na tik khaile ho na.
Taka, you are assisted by? And city?
I am Chen and Tushi.
Tushi Jamil.
Yes.
Santilo.
May I please your lordships? My learned friends have heavily relied on the maintainability of the writ petition. And in fact, they are right. Because lordships, if we look into the merits of the case, serious illegalities have been committed by the respondent authorities in the guise of making the amendment, the third amendment, even to the extent of circumventing the order passed by this Honorable Court on 12/5/2022. And in order to circumvent the court order, in order to overcome the order passed by this Honorable Court, this amendment has been made in the guise of the order passed by this Honorable Court. Within 6 days, the amendment has been made. And fact remains that when this amendment was made, at that relevant point of time, there was a gather review committee already constituted by the authorities for amendment of the service rules to do away with the hardships if it is caused to any of the employees. And there are as many as 3 orders of the authorities appointing the gather review committee. And during the pendency of this writ petition, that constitution of the gather review committees have also been revoked. That is just to overcome this litigation. Anyway, that is their prerogative. Another development that has taken place during the pendency of this writ petition is, of course, before replying to the submission, I'm just apprising the Honorable Court about the subsequent developments. The Commissioner and Secretary, who is above the Secretary, it is not a gather post, but the state government, in their best wisdom, has appointed a Commissioner and Secretary on deputation from the Lok Sabha. Because at that relevant point of time, there were no eligible officers having requisite length of service to promote to the post of Secretary. So it was a stopgap arrangement on the part of the government. During the pendency of, and the third amendment has also made some changes about his terms and conditions and about his appointments, because it was extended up to 65 years. Therefore, there were a lot of agitations by the members of the association, and ultimately he had to resign and he had to leave the post. Those are the developments that has taken place during the pendency of this writ petition. Now, coming to the submissions of my learned two friends on the issue of maintainability, firstly, let me just reply to the submissions made by my learned friend representing the respondent number 1, that is the speaker. There, firstly, 2 judgments have been cited in order to support his contention on the ground of maintainability. That is 1988 for ECC. This is a case, lordships, which is to do with filing up a petition by persons who are not aggrieved. The persons who has filed the writ petitions were not aggrieved parties, but then a writ petition has been filed. Therefore, writ petition has been dismissed because they are not the aggrieved persons. So far as our case is concerned, lordships, we are the members of the associations are governed by the service rule of Nagaland Legislative Assembly Conditions of Service Rules 1999. We are governed by one service rule only. There is no 2, 3 service rules, only one service rule, and our rights flows from that service rule. In other words, our service conditions are governed by the conditions laid down in the service rule. And the third amendment has taken away our rights, which has been conferred by a validly framed service rule. To that extent, we are aggrieved. Yes, no doubt, I may be holding a post in the lower category. But then, when a post in the top level, a higher level, is being filled up illegally, or for that matter, by a person, by an officer, who is not in the cadre and brought and made to occupy the post, definitely there will be a chain effect from top to bottom, and our chances to be considered for promotion will be affected, firstly. Secondly, it will let down a bad precedent in the department by amending the service rule at the whims and caprice of the authorities. We don't want this to happen. Therefore, the members of the associations are aggrieved because we don't want the department to lay down a bad precedent in the department. Whatever is done with regard to the rules, it has to be done in accordance with the provisions of law. Before this amendment, there were 2 amendments. That is, once in 2005, that is the first amendment, and the second one is 2012. In both cases, department has constituted a gather review committee. Committee has examined the pros and cons, and it has submitted the report to the secretary, that is the authority. Secretary will place it to the speaker. Speaker will place it to the governor, and thereafter, governor may send back to the secretary, who in turn will lead in the assembly, and thereafter it will become a law. Now, in the last 2 occasions, Cadre Review Committee has been constituted. They have examined and submitted the reports, and the amendment has been done. So, even in the present case, the third amendment, which was issued by a notification on 18th of May 2022, we were expecting that, yes, it has to be done in accordance with law, because on 12/5/2022, this Honorable Court has passed an order to the effect that if the authorities, if the respondents wants to restructure the gather, amend the service rule, that can be done only in accordance with law and after due consideration of all the stakeholders. So all the stakeholders, the employees of the Assembly Secretariat, the members of the association are the stakeholders, because we are all governed by one service rule. Therefore, that has been done without authority of law. This has been done in an arbitrary and unreasonable manner. Therefore, the members of the association are aggrieved by the illegal action of the respondents. Therefore, they have convened a meeting, taken a decision to approach this Honorable Court, and in the meeting on 23rd May 2022, the president of the association has been entrusted to represent the association. That resolution is also there. I will place it at the relevant time, Lordships. So this is how we have been doing. Now, by relying on the ruling of 1988 and 2010 to JLT, the ratio which my learned friend has relied upon, the ratio laid down in these 2 cases, are not relevant so far as we are concerned, because the 1988 decision is a case where the writ petition has been filed by persons who are not agree parties. But so far as we are concerned, I'm submitting before the Honorable Court that we have a grievance and our rights have been taken away by the amendment. Therefore, we are agree parties. Their case was they were not agree parties. Court has accepted. Therefore, yes, a person who is not aggrieved cannot approach this court, the Honorable Court. That is agreed. But so far as we are concerned, we have a grievance. We are aggrieved by the unreasonable amendment of the service rule, that too in violation of the Honorable Court's order passed on 12/5/2022. Because on that day, an officer who was an ex-cadre was brought to the gather, and four petitioners challenged that no, this cannot be done in this manner. And then this Honorable Court has quashed the notification of 1st November 2021, and then, of course, liberty was given. Taking that liberty, they have amended this. So the first citation which my learned friend has relied upon, I would submit that, Lordships, so far as our case is concerned, ratio is not applicable because we are agree persons. The other case which my learned friend has referred to, reported in 2012, that is JLT, the Shillong Wine Dealers Association. Yes, Shillong Dealers Association, they were a registered trade union, registered society. And mostly on this registration of union and all this, most of the cases are on the trade and commerce, because trade unions are formed, associations are registered, all these things, profit and loss. Now, subsequently, the Shillong Wine Dealers Association has been rechristened and met as Meghalaya Wine Dealers Association. And that was not registered. Therefore, from one registered trade union to another unregistered trade union, that was the issue. And the Honorable Court said that no, unregistered trade union association cannot approach this court. But then, so far as our case is concerned, Lordship, who are we? We are a service association. Nothing more than that. Not for any profit, but formed so as to protect the rights and interests of the members of the association, not for any other profit and loss or any other gain. Therefore, Lordship, the ratio of Shillong Wine Dealers Association and Chinchingdo Meghalaya Dealers Association, which is not a registered association, that ratio is also not applicable so far as we are concerned. And with regard to the separation of facts and the registration of association, as of now, there is no order of the association, order of the government de-recognizing our association. And there is no order of the government de-recognizing our association. So we are still a valid association. Now, my second leg of submission is, Lordships, there are 4 petitioners. Whatever objections my two learned friends have raised are pertaining to affidavit and the registration of the association. Yes, suppose if the petitioner petition is rejected on the ground of non-registration and on the technicalities, there are 3 other petitioners who are not the association, but they are approaching this Honorable Court in individual capacity. Therefore, Lordship, in that connection, I would like to refer, may I read out, Lordship, paragraph 1 of the petitioner, how the writ petition has been filed. There are 4 writ petitioners. Page 4. I preferred not to trouble your lordships by opening, just I wanted to read anyway. Since lordship has got, may I read lordships? That the petitioner number 1 is a registered association known as the Nagaland Assembly Secretariat Staff Association, hereinafter referred to as NASA, represented by its president, Shri Pakayanda, and the general secretary, Srimati Taliranna. The petitioner number 2, 3, and 4 are not members of the NASA, but they are equally affected by the arbitrary action of the respondents. The petitioner number 2 is the senior-most additional secretary in the Nagaland Legislative Assembly, and the petitioner number 3 is the senior-most joint secretary, and the petitioner number 4 is the second senior-most joint secretary in the same department, and they are all adversely affected by the illegal and arbitrary amendment of the rules, and the petitioner number 2, 3, and 4 are all eligible for promotion to the next higher post, and as such, they are entitled to all the rights and privileges guaranteed under the Constitution of India and the laws framed thereunder. Some of the primary aims and objectives of the association is to safeguard and further the interests of the association, to represent the grievances of the members on constitutional line, and seek redressal by the constitutional means. All the petitioners have a common cause of and grievance, and as such, the petitioners are filing a common writ petition for the ends of justice. So, even assuming that with regard to the technicalities, taking the technical ground, the petition filed by petitioner number 1 is not maintainable. There are other 3 petitioners whose right has been affected. And in one line, I have mentioned, Lordship, that petitioner number 2, 3, and 4 are not the members of the association. How? Because it is in the below the rank of joint secretary, they are the members of the association, and above joint secretary, they are officers, higher officers, so they are not the members of the association. That is what it means, Lordships. And thirdly, Lordships, with regard to the locus standi, page 45 has been referred to, that is the imbued order, the third amendment, by which the rules have been amended. And my learned friend, Mr. T.P. Jamir, has made a submission that the legislative confidence, the enactment, can be questioned only and referred by the court, only on 2 grounds. Number 1, legislative confidence. Second, if there is violation of fundamental rights. These are the
Sorry to
only-
interrupt you, Lordship.
Ah,
That is
yes.
not what I submitted. This is what the Supreme Court said as per the case law, not my submission.
The case law laid down by the Supreme Court has been submitted by my learned friend. I'm just reciting that. Now, so far as the legislative confidence is concerned, the part 1, I'm not refuting his submission because the law is very clear.
You're not taking that ground.
Yes. I'm not taking that ground because they have the confidence. We are only questioning the process, how it was done. And by doing so, whether any fundamental rights of the petitioners or any legal rights of the petitioners have been violated or not. That is the only issue. So I'm coming to the second part because so far as legislative confidence is concerned, they have the confidence, but Lordship may consider one aspect there. A law laid down made by the Parliament and a law laid down by the state legislature under Article 162 and 167 or under Article 186, like that. Now, this is a law framed under Clause 3 of Article 187 by the Governor. Yes, no doubt. It cannot be compared with any role framed under Proviso to Article 309 or, for that matter, Article 309 and Article 311 of the Constitution of India. But this is a rule framed by the Governor taking the power from Clause 3 of Article 187. And the ratio which has been laid down in most of the cases with regard to the legislative confidence are cases where the enactment made by the Union Parliament as well as the enactments made by the state legislatures are being questioned, are being challenged. In those cases, this ratio has been laid down. That only on two grounds. Court can interfere on the legislative competence. But this is a role framed under Clause 3 of Article 187 by the governor. And how it is done, it is very funny also at the same time. I will cite a short instance. By filing affidavit by the respondent number 1, a categorical contention was taken that this amendment, third amendment, has been met in terms of the order passed by this honorable court by judgment and order dated 12/2/2022, passed in WPC number 323 of 2021. 323 of 2021. And the date of judgment is 12/5/2022. However, very interestingly and surprisingly also, on 10th of May, 2 days before the judgment, the draft has been prepared by the Commissioner and Secretary, who is no more there. He has prepared on 10th. They are saying that this amendment has been done in terms of the direction and order passed by this honorable court on 12/5/2022. But then 2 days before the judgment, he has prepared the draft. Speaker has approved this on the same date, that is 10/5/2022. On the same date, the Chief Minister has approved this. Supersonic speed. On the same day, that is 2 days before the judgment passed by this honorable court. My only question, and which I don't understand, is, it failed by my logic, how the Commissioner and Secretary has visualized, came to know about the judgment 2 days before the judgment has been passed. Because of this reason, on the last occasion, this honorable court has directed the counsel for the respondent number 1 to produce the records. Now, so far as fundamental rights are concerned, Lordship, to substantiate that there is no violation of any fundamental rights or legal rights, an argument has been advanced that, look, the members of the associations are below the rank of joint secretary, so how they are affected? Because changes is in the top level, in the rank of secretary and the joint secretary. So if at all, if any person is aggrieved, then it can be the person who is to fill up the post and who is going to be affected. But as I was submitting earlier, Lordships, there are 3 other petitioners whose rights are affected. Not only that, the officers who are below them will also be definitely affected, because if the post of Commissioner and Secretary, of course, it is outside the gather of the present service role, and government has done it in their wisdom. He's doing it. He was doing all the administrative works. The other is this additional secretary. Additional secretary. There are two additional secretary. One, ex-cadre post, which was upgraded personal to the incumbent, and the petitioner number 2 is in the channel cadre, that is in Schedule A, who is the additional secretary. Now, an officer who is not in the cadre has been brought to the cadre and made to occupy a post. Then, definitely it will affect all the employees down to the bottom. That is how we are equipped. My learned friend was making a submission that
How do you make a submission that the person who is occupying the post is from an ex-cadre post?
yes, I will come to that. Now, how they are equipped? That was the submission. Then he's not coming. Are you saying that he's not coming to the cadre? He is definitely coming to the cadre. That is why we are affected. Otherwise, if she's not coming to the cadre, we cannot be the affected persons. To respond to what Lordship has said, in 1996, both the petitioner number 2 and the respondent number 3 has been appointed on the basis of a selection. But as luck would have it, I was appointed as assistant research officer. She was appointed as assistant transfer officer, the respondent number 3. And thereafter, promotions were effected to the next higher grade, incidentally on the same date, up to the transport officer. The post of transport officer has been upgraded personal to the incumbent because she was not in the cadre. Thereafter, it was upgraded to the post of joint secretary. It was upgraded to the post of additional secretary. In all the orders, it is categorically mentioned that the upgraded post is personal to the incumbent. When it is made personal to the incumbent, I cannot go there, nor she can come, because that is earmarked for the person concerned, incumbent. Now, since there is a rule of amendment of 2012, which says that there can be no interchangeability between the cadres. There are as many as 8 cadres under the schedules. Schedule A is general, Schedule B is transport, like that, and then one schedule is drivers, one schedule, and then another schedule is for the stenos. So up to Schedule H, A, B, C, D, H, as many as 8 schedules. There, the other cadres cannot come to A. A cannot go. 2012 amendment says there can be no interchangeability or intertransferability of the different cadres in this schedule. That's how some of the employees who are in the different cadres may happen feel agreed. Therefore, what happened is, since the private respondent number 3 and the petitioner number 2, they were promoting to the same date, on the same date, to different higher posts, but petitioner number 2 has been promoted in normal process. So far as respondent number 3 is concerned, she has been promoting from time to time, personal to the incumbent, by upgrading the post, personal to the incumbent. After reaching the rank of additional secretary, it was also personal to the incumbent. So the respondent number 3 filed a writ petition before this honorable court. Firstly, before approaching this honorable court, she filed a representation that, look, I have no promotional avenues, therefore, my case may be considered. But then it was pending for about 2-3 months. Thereafter, she filed a case with the sole prayer that I have filed a representation and that is pending. A direction may be issued to dispose of my representation. With that prayer and the day of motion, which the counsel for the respondent number 1 has not resisted and agreed rather, and a direction was issued by this honorable court directing the respondents to dispose of the representation filed by the petitioners, that is the present respondent number 3. This representation, this order passed by this honorable court has not said anything except directing the authorities to dispose of the representation. In what manner it has to be done, it was not said. But then taking power from there, taking advantage of that, because it is almost like a design, the respondents has, by a notification of 1st November 2021, brought to the gather, to the channel gather. The ex-gather post of Additional Secretary Transport has been brought to the channel gather. And on the same date, by a notification on 1st November 2021, she was regularized. This notification and the office memorandum came to be challenged by 4 petitioners on the ground that, look, without amending the rules, you cannot do this. If you want to bring her, you can amend the rule and then do it. We will have no objection. But then the manner how you have done is not in accordance with law. Therefore, we don't subscribe. This honorable court has allowed the writ petition and came to the categorical finding that the private respondent number 3 is holding an ex-gather post personal to the incumbent. She cannot come to the gather in terms of the service role because Rule 10 is very clear that there can be no intertransferability between the gatherers. That was passed. And another provision was left. However, if the respondents want to restructure the gatherers, then they can do so, which can, the word only is used, lordships, which can only be done in accordance with law and taking into consideration of all the stakeholders. Now, what is in accordance with law? As I was submitting earlier, in accordance with law can be constitution of gather review committee. Committee will examine, submit a report, and thereafter take an appropriate decision. Secondly, taking into consideration of all the stakeholders. Now, who are the stakeholders? The employees of the Nagaland Legislative Assemblies are the stakeholders. We are all equal so far as the rights are concerned. But without taking into consideration of all the stakeholders, within 6 days, things have been done and an amendment has been issued. Therefore, this writ petition has been filed. Look, when there is an order passed by this honorable court to do the things in a particular manner, why you have done in this manner? This is not in terms of the court order. Rather, this amendment has been made so as to circumvent the order passed by this honorable court. What you cannot do directly cannot be done indirectly. And this is what this has been done in this third amendment, lordships. That is how we are agreed. Look, we are the stakeholders. At least if you want to amend the rules, yes, you can do it because you have the power. But please do it in accordance with law. Follow the procedure and do it. If my information is correct, lordship, governor was out of station at that relevant point of time. Through software, all these things, signature obtained from Gauhati. And this has been passed. Hurriedly, within 6 days, a rule has been amended. Whereas cadre review committee has been constituted and it is all along pending. That's how we are agreed from top to bottom. We are agreed persons. Therefore, the writ petition. And another point, lordship, sorry, I have left out one point. Article 13. Any law which is inconsistent with any enactment, which is inconsistent with any law, can be declared as void. And if we look further, the clause 3, what is the law? Law orders all this. Order passed by this honorable court is a law under Article 13 of the Constitution of India. And when this honorable court has given a categorical finding to do certain things in a certain way, why that was not followed? Therefore, is it not violation of fundamental rights? Article 13 is a fundamental right. An order, direction passed by this honorable court is an order. An order is coming within the definition of law under Article 13 of the Constitution. Therefore, it cannot be said that the fundamental rights have not been violated. Our rights have been violated when the authorities are acting to the extent of circumventing the court's order, the order passed by this honorable court. Is it a case to be just thrown out on the mere technicalities when serious injustice has been done? Now, to throw a balance with regard to the technicalities on one hand and the injustice that has been done by the authorities, to strike a balance, which one should be given the precedence and preference? Definitely, this long arm of this honorable court can interfere where the injustice has been done. And this is one classic case, Lordship, where the respondents has violated the order passed by this honorable court, ignored all whatever they have done. And another aspect, we have also challenged that this enactment is contrary to the Nagaland Retirement from Public Employment Act. How? Both lordships are well aware and conversant about the Retirement Act, the date of retirement. The age of retirement is length of 35 years and 60 years, whichever is earlier. By this amendment, since at that relevant point of time when the rule was framed, one blue-eyed boy, Dr. Anthony, was occupying the post of Commissioner and Secretary. After expiry of his extension order, after his retirement, on completion of 60 years from Lok Sabha, again he has been appointed and discharging the entire powers and functions which can be discharged by a cadre post holder. After retirement, one can be at best appointed as a consultant or an advisor, but not like to exercise the entire powers and functions of a head of the department. Otherwise, the Retirement Act becomes meaningless and the tenure has been fixed up to 65 years.
That
So-
65 years was made personal to that officer concerned. That 65 years was made personal to that officer.
Yes.
Correct?
No, it is not mentioned personal.
Acha.
That is why it is
It
a,
is still there in the rules. It is still there in the rules.
yes, new amended rules. Now, we are questioning this also. Look, roles have been framed tailor-made. Why I'm submitting that tailor-made? Submission has been made that below the rank of joint secretary, they are all below the rank of joint secretary. How they are affected? That was the submission. See, out of the 8 schedules, only 3 schedules where there is post of joint secretary and above joint secretary. Only 3 schedules. Schedule A, and then transport wing and steno wing. Now, so far as general wing, schedule A is concerned, that is okay. With regard to the transport wing, the sanction post is only up to the transport officer. That is the reason why in the upgradation order of the respondent number 3, it is clearly mentioned that once she is reverted back, it will go to the post of transport officer because that is the only sanction post. And the other schedule, that is the last schedule, which is the steno. The post of steno or steno speaker, this has been created only for the stenos in the rank of additional secretary, but it was created only for the stenos, but it was made interchangeable. Now, the reasonableness. If a steno can come and occupy the post of additional secretary, can a person go to the post of OST to a speaker, which can be manned only by the stenos? Because the post creation order clearly says that only for the stenos. Then we cannot go. Therefore, why unreasonable law? Only one can come and others cannot go. That is the reason why we are making the allocation of statement of tailor-made. And so far as the transport wing is concerned, the post held by the respondent number 3 has never been indicated. Even now, the post held by her is not indicated, but she has been allowed to hold the post.
There was restructuring.
Restructuring, but yes, intertransferability was allowed by the restructuring. Intertransferability has been allowed. But except her, no other persons can come from the transport wing again. Therefore, only 3 schedules out of 8, which has got the post above Joint Secretary.
This is entering in the merits.
Therefore, that is how, Lordship, I was making a submission initially that it will be necessary to go into the merits thereafter. After understanding the merits of the case, then whether it is maintainable or
Confined to
not.
maintainability,
Yes.
then you can argue on merits.
Now, therefore, entire amendment, because it is a tailor-made, because this has been made so as to suit only some individuals, not all. Therefore, we are saying unreasonable, illegal, because when it is not done in terms of the orders passed by this honorable court, I would say that that is illegal. A thing which has been done not in accordance with law can be illegal. And when there is illegality, definitely this honorable court can interfere. Now, that is under submission made by my learned friend representing respondent number 1. Coming to the submission of respondent number 3, Lordship, private respondent, he has referred to the prayer portion in the writ petition and then went on to make a submission that it is a blanket challenge, not specific. In this regard, Lordships, I would like to make only one submission, one-line submission, that entire amendment is illegal. Therefore, we are seeking to interfere with the entire amendment, not sporadic, not piecemeal, not partwise. Because we are all governed by the provisions of the present service rule, and when it has been done, amended in an arbitrary and in illegal manner, then our rights has been affected. Therefore, the entire amendment has to go. Otherwise, it will let down a bad precedent even in future. The third one and the most important point, Lordships, admittedly, there is an order passed by this honorable court on 12/5/2022. This order has not been challenged either by the respondent authorities and also by the private respondents or the parties. Gladly, they have accepted the judgment and order. But, and in that judgment, there is a clear stipulation and observation and direction by this honorable court that if you want to make the structuring, you can do it only in accordance with law and by taking into consideration of all the stakeholders, whether the interests of all the stakeholders have been taken into consideration or not. That is to be looked into. Whether this has been done in accordance with law. So far as my submission is concerned, Lordships, the present issue relates to amendment of the service rule. In the past, in 2005 as well as in 2012, amendment has been made on the service rule by constituting the cadre review committee, because this is an expert committee who can examine all the pros and cons and then merits and demerits, and they will submit a report to the secretary, and then secretary will follow the due process of law. That is how it has been done in the past. The recent third amendment has been done in such a way, in an abnormal and unusual manner, by circumvening the court order passed on 12 May 2022. Therefore, Lordships, it is liable to be interfered with by this honorable court. And as I was submitting earlier, the proposal for amendment, which was allegedly done in terms of the court order, has been done 2 days prior to the passing of the judgment by this honorable court. Therefore, I would submit that a false affidavit has been filed by the speaker. Therefore, this honorable court should not take it lightly in such illegal actions, Lordships. President notarized us again. President notarized us. Wrong judgment. I have only 10 minutes left.
Mr.
to
Siti.
Lordships.
How do you know that actually the rules were amended 2 days before the draft?
Yes.
2 days before the judgment.
Exactly.
How do you know
That is very relevant question. In their affidavit, in the affidavit of the respondent number 1, there is a categorical statement that this amendment has been done in terms of the judgment and order dated 12/5/2022. And that proposal has been made 2 days before. 10 May is before 12 May.
Correct.
I have enclosed
Can
the
you-
document.
Yeah, can you just show us
Yes.
that proposal?
Affidavit in opposition of respondent number 1.
Affidavit number, respondent number 1. Which page?
Affidavit in opposition of respondent number 1.
Yes.
First, I would like to refer to that.
Yeah.
Has your Lordships got it? May I read, Lordships? That I am impleaded as respondent number 1 in the present writ petition. I am conversant with the facts and circumstances of the case and competent to swear this affidavit. So he is saying that he is conversant with the facts and circumstances of the case. Keeping this in mind, kindly come to paragraph 10 at page 11. May I read, Lordships? Paragraph 10. That in reply to the statements made in paragraph 11 of the writ petition, it is stated that this honorable court, while setting aside the impugned office memorandum dated 1/11/2021 and notification dated 1/11/2021, by judgment and order dated 12/5/2022, has also observed that the same shall not debar the respondent authorities concerned from considering the restructuring of various posts under the Assembly Secretariat, which should otherwise only be done in accordance with the relevant provisions of law and taking into consideration the rights and interests of all stakeholders. It is stated that this Honorable Court has quashed and set aside the Office Memorandum dated 1/11/2021 and notification dated 1/11/2021 as the same were not issued in accordance with the relevant laws. Accordingly, the service roles, accordingly is very important, Lordship. Accordingly means according to what? According to the judgment. Accordingly, the service role has been amended as per Article 187, Clause 3 of the Constitution of India, and restructuring has been done after taking into consideration the rights and interests of all stakeholders, including the larger interests of the NLAs. It is stated that the defect pointed out by this Honorable High Court has been removed by amending the service roles as provided under Article 187, Clause 3 of the Constitution of India, by taking into consideration the rights and interests of all stakeholders. Therefore, the contention of the petitioners that amending the service role has met the judgment and order dated 12/5/2022, passed in WPC number 323 of 2021, redundant and ineffective is not correct. Now, reading the entire paragraphs shows that the amendment by notification, the amendment has been done in terms of the judgment and order dated 12/5/2022, whereas the draft service role of this amendment has been prepared 2 days before the judgment on 10/5/2022 prior to the judgment. Can we come to my affidavit and reply?
Your reply to respondent number one.
Yes, affidavit in reply to
Respondent number one.
the respondent number one.
Yes.
This has been sought through the RTI Lordships, page 16, Lecture 3. Has your Lordship correct? Office of the Commissioner and Secretary, NLA. Subject amendment of so-and-so, so-and-so, in line with the Honorable Speaker's direction dated 13 October 2021, while disposing of the representation submitted by Srimati Catherine Rio in the context of the order of the High Court. That was earlier proceeding on the issue. Certain necessary amendments pending the completion of the process of comprehensive revision of the rules being undertaken currently in the Nagaland Legislative Assembly Secretariat, conditions, recruitment and conditions of service rules 1999, Second Amendment rules 2012, incorporated are proposed as in the draft placed below. If approved, we may request the Honorable Chief Minister to place it before the Honorable Governor for his kind approval. Now, Commissioner and Secretary, he has proposed it on 10 May 2022, and thereafter it was placed to the Speaker, and Speaker has approved on 10 May 2022. Thereafter, it was sent to the Chief Minister. He has approved on 10/5/2022. And Governor, apparently, he approves on 18/5/2022 by online from Gauhati. So, any action, Lordships, any action with regard to the amendment of the service rules that was already in the process, and all those came to an end on 12/5/2022 while disposing of the writ petition number 323 of 2021. Everything has been examined by this Honorable Court by the judgment. Earlier proceedings. Everything has come to an end. Now, we are in the affidavit. The Speaker has categorically mentioned that this amendment has been done in terms of the order passed by this Honorable Court on 12/5/2022. However, the draft has been prepared prior to the judgment. And they are saying that this has been done in terms of the judgment passed by this Honorable Court. So, in view of these lordships, on the last occasion, this Honorable Court was pleased to direct the respondent authorities to place the records. And this, it was on 23/8/2022. This Honorable Court has called for the records, and my learned friend has been directed to produce the record. That is 23/8/2022. Lordships can examine and then take an appropriate decision.
continue tomorrow.
And I will,
Tomorrow.
yes. And that is,
TB Jamil, on the issue of operation of law, with regard to
Lordship.
the register.
Lordship. Okay, I'll look. And one more thing, Your Lordship, in my affidavit, I have not stated that amendment has been done pursuant to the judgment order passed by this court. No. Whatever amendment has been done, we have taken consideration of all the stakeholders, which is in terms of the direction passed by this court.
But
I have not
Jamil,
stated pursuant to.
when senior counsel assisted by Mr. IMG, Tushi Jamil, for the petitioner in WBC 92 of 2022. Also had Mr. TB Jamil, learned counsel for respondent 1 and Mr. Takamasa, the senior counsel, assisted by Mr. Arno and Cindy Law for respondent 13 part. Please for further hearing again on 31st.
Obliged.
lordships.
Keep this books here. Clip this.
this meter has been wrongly listed. As per the order dated 24/1/2023, it has to be listed after 2 months, 2 weeks.
Can I take up this matter? If
Yes, Lordship.
I can take up?
Yes, Lordship.
Okay. Give me the file. Which order? 24.
24/1, Lordship. 24/1/2023.
After 2 weeks, 24.
It's supposed to be listed on 7 of this month, next month.
Okay. List this matter in terms of the order dated 24/1/2020.
Yes, Lordship. Obliged.
May it please, my lord.
Yes.
I may be allowed to make a mention for hearing item 13, my lord, on behalf of my learned friendly Matushi. My lord, it may kindly be listed on 13th of March, my lord.
On request made on behalf of Ali Matushil and Council for Petitioner. List on 13th March.
Much obliged, my lord.
13th.
Please, Your Lordship. Lordship, I beg to mention item number 10 with the consent of the opposite party. And this may be, let the matter be fixed on 13th of February.
Heard Cindy Angle and the Council for the applicant. On request made by MS
Kate Sikra.
Kate Zuckerl and Council for the opposite party of the fifth petitioner. List the matter on 13th of
February.
February.
Obliged, my lord.
Mercy, Lordship.
May I please, Your Lordship? Lordship, I'd like to mention item number 8, Lordship.
8.
Lordship,
Yes.
Lordship, I'm yet to file my affidavit, so Lordship, can you grant me some time, Lordship?
How much time?
2 weeks, Lordship.
You
Please, Your Lordship. Lordship, this case is pending for a long time. Similarly situated person has been already appointed, and my senior is under much pressure from the client. Therefore, it's my humble prayer that last chance may be given.
Okay. Heard MS, your good name? Your good name, please?
Kelly Lisu.
Lily Su, the Council for Petitioner. On request made by Ms. Supungla,
Lordship,
the government advocate. 2 weeks,
2 weeks, Lordship.
3 weeks time. 3 weeks time as last chance is allowed to file counter affidavit. List after 3 weeks.
May I please, Your Lordship? Lordship, I beg to mention item number 5 on behalf of the Divika, Lordship. If this matter, item number 5, Lordship. If this matter can come out after 3 weeks, Lordship.
Okay. Heard MS Kelly Lisu, the Council for Petitioner, on request made on behalf of Ms. MS
Ms. Divika.
Lordship,
Devika.
may I please, Your Lordship? Same prayer, yeah. Last
List-
chance may be
list.
given. Item number
3
5.
weeks time as last chance is allowed to file contract. List after 3 weeks.
May I please, Your Lordship? I also beg to mention item number 5 on behalf of Madam Lucy, Lordship.
That earlier item was which item you mentioned?
Yeah, it was 5.
That
Now,
was,
I'm praying for item number 9, Lordship.
yeah,
If Lordship may kindly grant me 2 weeks, Lordship.
2 weeks time.
My lord,
Yeah,
of course, I don't know the constitution of this honorable court, my lord. However, my lord, considering that, my lord, it may be rare for your lordship to be here, my lord, if it can be listed next week, my lord.
next week also, are you sure I'll be here?
Then, my lord,
Let's take a chance then.
yes, my lord.
Heard Cindy Younger, then the Council for Petition. On request made by Ms. Who, list the matter. After 1 week,
My lord,
after 1 week.
highly obliged, my lord.
Lordship, I also beg to mention hearing item number 15, Lordship. On-
15 is adjourned.
Oh, Lordship. Obliged, Lordship.
My best Lordship, I beg to mention admission item number 3. I pray that it may be listed on 2nd of February, Your Lordship.
Okay, on request made by Subhamati Wali, then the Council for Petition. List the matter on second February?
Yes, ma'am.
Second.
Much obliged.
Obliged, Lordship.
For motion, item number 1.
May it please your Lordship. Lordship, by this read petition, I'm sealing the appointment order of respondent number 5, Lordship. This appointment was made in violation of the constitution scheme for public employment, Lordship. There was no selection process, Lordship.
Where's the order?
Lordship, we'll find the order at page 26. May I read it, Lordship?
Has he taken over charge?
No, Lordship. I've stated paragraph 18 of my read petition, Lordship. Please.
More Jamir, Leonard Council for Petition. Issue notice. MS Supongla, Leonard Government Advocate, enters appearance and accepts notice on behalf of respondents. 1, 2,
1 to 4.
3, and 4. Stop. Petitioner to take steps for service of notice on respondent number 5 by registered post AD within 1 week.
Lordship.
From today. List the matter after 4 weeks. In the interim, the notification dated 13 January 2023, appointing the private respondent number 5 as multitasking staff under the establishment of STIC, Champangya, shall remain suspended till the next meeting.
Much obliged.
For motion, item number 2.
I have been subjected to unnecessary proceeding, Lordships.
Has this Lok Ayukta Act been amended?
No.
No.
Yes, and it doesn't come under the Lok Ayukta because
No, no.
service matters are
That
exempted.
is something different.
Yes.
That's for my personal.
Yes. Whether Lok Ayukta Act has been amended.
No,
Not yet.
I don't-
Who can be appointed as Lok Ayukta?
Appointed. Yes, it is appointed. Lok Ayukta has been appointed.
No, that's what-
Banu Z. Chamir.
Banu Se Jamir.
Who can be appointed as Lok Ayukta
Lordship,
if it is not amended?
If I'm not mistaken, Lordship, there was some certain amendment with regard to the qualification and the criteria. If I'm not, but since I'm no more the Senate Council, Lordship, not the proper, but I think there was been some amendment in the act.
Who's appearing?
my Lord, I'm appearing for respondent number 2.
2.
Yes, my Lord.
2 is who? Chief Engineer.
Chief Engineer.
Yes,
Heard
he is
City
performer
Jamal
respondent.
Senior Counsel assisted by MS
Toshi Chamir.
by Tushi Jamal. She's Tushi Jamal.
Toshi Chamir, yes. Miss Toshi Chamir.
Okay, MS Tushi Jamal, Leonard Council for the petitioner issue notice. Mr. T. Bapom, non-government advocate, enters appearance and accepts notice on behalf of the pro forma respondent number 2. Petitioner to take steps for service of notice on respondent number 1 by registered post AD within 1 week from today. Where's the order?
Page 36.
36. List the matter after 4 weeks. In the interim, the order dated 7/12/2022 issued by the Upal Lok Ayukta in case number A-NLP-34/2022 shall remain
And I
suspended.
bring for further proceeding of the case in prayer portion, page 14,
Shall remain suspended.
because they may issue fresh
And-
summons also.
And further no, in the interim, the order dated so and so, passed by the Leonard, passed by the
Upal Lok Ayukta.
Upal Lok Ayukta, as well as further proceedings of case number A-NLP-34 shall remain suspended. Till the next meeting.
Much obliged.
For admission, item number 4.
Yes.
Lordship, I am for the private respondent, my lord. My lord, in fact, this case has already become infructuous, my lord.
Is it correct?
No, Lordship, I'm appearing on behalf of Taka Kichu, Lordship.
Yes. Where is he? I've not seen him for quite some time.
He's out of station as of now, Lordship.
So what do you want? You want to argue the matter or
No, actually, he wanted me to adjourn the matter
when?
after 2 weeks, Lordship.
On request made on behalf of Mr. Tabakichi, then the counsel for petitioner. Please stop 2 weeks.
Obliged, my lord.
For admission, item number 6.
Yeah, Mr. Lordship. Lordship, I ordered dated 15/11/2022, Lordship. This honorable court has passed an order because in the last occasion also the petitioner did not did not appear before the court. And no reason was given, Lordship. And if Lordship may kindly see 15/11/2022. If the petitioner fails to appear, Lordship, the interim should be vacated, Lordship.
Yes.
Your Lordship, I'm appearing on behalf of the petitioner. I was told that he's out of station, Sir Nguli. So he praised that this matter may be listed on the second week of February, Your Lordship.
Is it W.R. Muli?
Yes, Your Lordship.
Then
Lordship, he has not filed any letter of absence also.
whatever this, he's making some representation.
No, Lordship, taking in consideration, because the interim, Lordship, the first interim order that was granted, the petitioner has misled the court and he has obtained interim order for the whole Gauhati district, where he is concerned only with Sunny's village. Now an application was filed by the state for modification of the interim order. And the interim order was modified to the extent that it will affect only the Sunny's village, Lordship. Thereafter, Lordship, taking undue advantage of the interim order, Lordship, he's avoiding the court. And
Yes.
Lordship, it's already 1 year over. Village council, we are unable to perform because my village council.
There'll be no adjournment next time.
Okay, Your Lordship. Since this time he's under medical, he's out of station for medical treatment, Your Lordship. So I kindly pray that this matter may be listed.
Lordship.
On request made on behalf of Mr. W.R. Muli, then the counsel for petition. List the matter up to 2 weeks.
Lordship, if we can be fixed, Lordship.
List the matter on, when do you want?
On 15, Lordship. 16?
16
Is it
February.
Okay,
Okay, Your Lordship.
16th of February. It is made clear there shall be no adjournment on the next day.
Obliged.
Much obliged, Your Lordship.
For admission,
Interim
item number
order is
7.
there? No interim.
Lordship, for respondent number 3, the private respondent, Lordship.
Item?
Item number 7, Lordship.
Oh,
I may be allowed 3 weeks' time to file affidavit in opposition, Lordship.
your good name, please.
Lucknow, Lordship.
Heard Mr. Nakipom, Leonard Counsel for Petition. On request made by Mr. Muajami. Leonard Counsel for respondent number 3.
Lordship,
How much time?
3 weeks' time, Lordship.
3 weeks time is allowed to file contra affidavit. List of the 3 weeks.
Much obliged.
For admission, item number 11.
May I please, Your Lordship? Short matter, my lord. All the parties are ready for the final hearing, my lord. The petitioner has been excommunicated as well as barred from entering his village because he intends to contest the election against the decision of the village authorities.
Lordship, before my learned friend make his submission, that I is also there, but I'm I'm giving a proposal, Lordship, subject to what the Lordship sees and what my learned friend says. So far as the violation of constitutional rights are concerned, where the rights of the writ petitioner have been affected, I'm considering to all these points because I don't want to argue to defend an electoral order which is adversely affecting the constitutional rights of any citizens. So to that extent, I'm considering that. In that connection, Lordship, in the writ petition, there are 5 prayers. Under caption A, there are 4 prayers from 1 to 4. And then under caption B, there is another prayer that is to issue a direction to the deputy authorities to conduct free and fair election and all that. To that extent, the Deputy Commissioner on 5th January 2023 has already issued a circular, general circular, directing to all the village councils and the citizens to have not to interfere with the election matters. So far as that prayer is also already done by the authorities. With regard to the 4 prayers, prayer number 1, 2, 5. There are 5 prayers. Out of these 5 prayers, I'm considering prayer 2 to 5. Except prayer,
1 minute.
page 27.
Under A,
Yes,
A2 to 5,
yes,
you are considering.
yes.
What is 1?
One is granting renewed blessings to one Mr. Tongbang Ozakam.
Annexure 3.
Annexure
Yes, my lord, page 33.
In this connection, I would just like to refer to only 3 paragraphs to my affidavit, and if your lordship pleases, then lordship can pass appropriate orders. We are concerned with paragraph 4, page 34 of the writ petition. Vernacular version is at page 33. Since lordship is also conversant with this vernacular language also, lordship can also see paragraph 4.
So you're saying you've given only Shilomang?
Yes. Shilomang means renewed blessing.
Yes.
We are granting blessings. So in this connection, lordship, I will refer to 3 paragraphs of my affidavit, and thereafter lordship can, if lordship is satisfied.
Let me see.
Paragraph, affidavit in opposition. Paragraph 5, 10 and 11, lordship. First, paragraph 5. Happened, the existing candidate has been placed by the Somongtang.
Yes, indeed.
Yes, lordship. Lordship, insofar as I'm challenging this because
Why?
this is the basis, this is the genesis of all the actions that has been taken. Based on this.
This is only a blessing. It's called a Shilomang in how?
Yes, my lord. Yes, my
Okay.
lord. It is a blessing or a privilege
It's a blessing.
given to
The council is giving him a blessing.
lordship.
Sen Somongtang.
The Sun Sumangta is giving him a blessing. There's no particular thing as such that he is the only candidate.
He is the lordship.
Other ones I've seen the other resolutions. They are one way or the other attached, which violates the constitutional.
Yes, my lord. A village authority having pervasive regulatory monopolistic powers, my lord, over its citizens, is giving a blessing to one particular candidate, my lord. It's undue influence. It's undue influence, my lord. It's influencing the voters.
If you want to argue, then we'll take up tomorrow. Today there's shortage of time.
On this point also, my lord, I could like to press.
Okay, it's up to you. If you
Yes.
want to press,
And then,
I'll hear you.
yes, my lord. And
But
because,
I'm making my point clear.
yes, and based on this, my lord,
Shilomang can be given to anybody.
lordship, then it can be,
Even your client can go and take a Shilomang.
lordship, based on this, subsequent, they have referred to this decision. Lordship, this is how it happened. In this general meeting, in this Susumudang, my lord, there was an agenda. to have just one candidate from the village.
No, that agenda is not before.
No, my lord, I'm just how it prior to this, and then before the agenda was discussed, time was given to the Putumundan. Putumundan says we have already taken a decision, give blessing or privilege to the particular person, and my lord, that was accepted by the Susumu. And subsequently, based on the decision taken on 28 December 2021, my lord, circulars and dictates have been issued. It refers to this. It refers to this, my lord. Lordship, everything will become clear if your lordship looks at page 35. Page 35, my lord. Because this is referred. This is the basis. This is the genesis.
To decide all these issues, we have to go into we have to lead evidence. Who has said
Therefore,
what,
this,
who has
lordship,
done
if you
what.
look at this is no longer a Shilumang only.
Supposing this court quashes all the resolutions and leaves this alone,
Lordship.
will it affect you?
My lord.
Will it affect you?
My lord, because it will have an
If
influence.
this court quashes all the
Everything.
resolutions, everything except this,
Except the first one.
yes, will it affect you?
My lord, it may be that it may influence the voters of the village. Because, my lord, blessing has been given to one particular person, my lord, a statutory body.
Mr. Imti, I think you should take some, you should consult your client
Lordship.
and come back. I'll hear you tomorrow.
Fine, my lord.
Or tomorrow or day after is Wednesday.
Lordship, can you be pleased tomorrow? We want to finish it off.
Yeah, this one requires early disposal.
Yes, my lord.
See, my intention is,
Yes, my
I'm
lord.
making it very clear.
Yes, my lord.
There's no point of playing hide and seek.
Yes,
I'm quashing the whole thing.
Lordship.
Except this.
Accept this. And my lord,
Will it affect you? This is what I'm saying.
Lordship. Lordship, what about pair B? That is, my lord.
Obviously, that I'm going to pass the order.
Yes, to have it fair.
To have a fair. That is absolutely. I've been reading the newspapers also. Deputy Commissioner has been issuing notifications after notification.
Lordship.
Deputy Commissioner Mokchung
Yes, my lord.
has been issuing notifications
Yes, yes, yes.
to have free and fair.
Yes, my lord.
So that much I can say that ensure
Ensure.
free and fair election is taken.
Yes, yes.
Nobody should be victimized.
And this is just blessing,
And this is just a blessing.
which can also be given to the petitioner, if they pleases.
If he approaches and if the Sinsumong
We were willing to keep Andati also. He himself was present, but he did not
No,
come forward
no,
to
my
get the
lord.
blessings.
So if he approaches, they can give him the blessing.
Yes.
Lordship, can I just seek, can I just have 2 minutes and come back today itself, if it's possible, just to say, because I cannot concede anything without the.
No,
it will
that's
be
why
not
I'm
be
saying
problem.
I'll give you time till tomorrow morning.
Till tomorrow morning.
There's no problem.
Yes.
There's no issue.
Lordship
We'll
does not want to
dispose-
interfere with the first one.
We're trying to dispose this matter tomorrow itself.
Yes, my lord.
I'm quashing all the resolutions,
Yes.
notifications,
Lordship.
except the first one,
Insofar as of now is concerned, my lord.
as of now.
No, no.
So far, blessing is concerned.
As of now,
And if you
now.
approach, I can't tell them to give the blessing also. But
No,
they may
no.
give you.
What I'm saying is, my lord, as of
That-
now,
I don't know.
as of now, my lord, as of now, lordship has made up his mind to cost only 4, not the first one. Tomorrow I may be
Plus direction.
directions.
Free and fair.
Yes, my lord. And tomorrow I may, if my client doesn't agree, then I also make an effort, my lord.
Yeah, why not? Yeah, you're open to that. I'm open to that.
Yes,
I'm
ma'am.
just making a suggestion.
Lordship, very well, ma'am.
List this matter again on 31st.
Lordship, as the first item tomorrow, I mean at the top of the list, so that
Subject to, no, you can upgrade it.
upgrade it.
Yeah, you can upgrade it.
At the time, at 10:30, lordship, I'll make a mention.
Subject to motion matters.
Yes, ma'am. Much obliged.
Item number 12.
May I please, Your Lordship?
Yes.
My lord, the extra copy was served to me only this morning, so kindly allow me 4 weeks time. My lord.
How is it coming up for hearing then?
Order.
Orders, oh,
This-
orders,
yes,
orders, okay. Okay. Heard, Mr.
KRK.
K.R. Kachimil and the Council for Petition. Mr. Kibapong and the government advocate is allowed how much time?
4 weeks time, my lord.
4 weeks.
Lordship. May I please, Your Lordship? Lordship has taken step for respondent number 5 and 6 as well, by way of the ST.
Thursday?
Yes,
No,
Lordship.
no, then you said and heard so and so for the petition. Peruse the affidavit dated 15 December 2022, showing service of notice on respondent 5 and 6 by Justice Service. Stop. On perusal of the same, this court is satisfied, and accordingly, notice on respondents 5 and 6 shall be deemed to be complete. Stop. On request made by Mr. Kipapin and government. 4 weeks time is allowed to file court.
Obliged, Lordship.
For hearing, item number 14.
CRP,
Yes, my lord.
will it take time today?
My lord, there's a
I have
new
just
development, my lord.
half an hour, yeah.
Here, the petitioner village and respondent village, they have mutually settled the matter. So, my lord, by resolution dated 23 January to 23.
Can I have a copy?
Yes.
Yes.
Are you agreeable?
Yes, Lordship. I have been served.
My lord,
I can
on
close
the basis of
matter
this, on the basis of this,
by recording the resolution?
my
Yes,
lord,
Lordship.
yeah, withdrawing the matter, my lord.
Okay. Learned counsel for the parties submits that the opposing parties have settled the matter outside the court by a resolution dated 28/1/2023. Correct?
Lordship.
Stop.
My lord, 23rd, my lord, 23rd January.
Is it
Here,
23rd?
here,
Yes, my lord.
is it? Acha, 23rd
Yes.
January. Signature.
Oh, on top it is the
Yes,
signature.
23rd,
is-
yes.
Yes,
Signature is, okay. Then you say like this, Learned counsel for the parties, cancel the whole thing, submits that the parties have come to have settled the matter outside the court and have passed a resolution to that effect on 23rd of January 2023. Stop. The resolution dated 23rd January 2023 is reproduced here in below. Just again retype the whole thing. 8 stop. Para. In view of the resolution reproduced here and above, Mr. N.K. Loikam, learned counsel for the petitioner,
My lord,
prays for withdrawal of the present
my lord.
petition. Stop. Prayers allowed. MS
Z. Jimami.
Z. Jimami, learned counsel appears on behalf of the
Respondents.
respondents. Stop. The civil revision petition is accordingly dismissed on withdrawal. Dismissed on withdrawal.
Most please.
Obliged, Lordship.